Well, good evening all. Myself CA Samir Ledda, former chair of Pune branch. Welcome you all, the dignitaries on the screen and all the audience for this webinar on Section 148. CA CV Chitre sir in absentia, he is expected to join soon. Dr. Raj Chawla, Vice Chairman Directors Committee. I think he is also in absentia. He is also expected to join soon. CA Pankaj Soni, former chairman of Pune Aurangabad branch. CA Angej Kumar sir, all of you, welcome on this webinar of Section 148, and very renowned speaker and famous speaker Kapil sir, Kapil Goye sir, is really pleasant for all the audience, sir, to hear from you. You know that every chartered accountant of all over India want to hear you. So thanks a lot and welcome on this webinar. With this, Dr. Raj Chawla is there. Pankaj? Yes, Raj Chawla sir, welcome on this seminar. Namaste sir, good evening. I request you to kindly give the opening remarks for this session. Over to you, CA Raj Chawla sir. Sir, you are on mute, sir. Please unmute yourself. Raj sir,
thank you. Yes, sir. Thank you, Samir bhai. Good evening to all. First of all, I welcome all the participants to this very hot topic webinar on Section 148 on Income Tax Act. और हमारे साथ हमारे सीए एडवोकेट कपिल गोयल जी, वाह क्या बात है, आज तो धमाका होने वाला है हमारे वेबिनार में, क्योंकि आज तक मैंने देखा है जो हमारे कपिल भाई की प्रेजेंटेशन और जो बात करने का अंदाज है ना, बिल्कुल. तो सर, really I am very honored to have you, and I also welcome all the our panelists on this program. So thank you, Samir bhai. Now you can please start.
Sir, thank you a lot. As you said, when Kapil sir is there, dhamaka to hone hi wala hai, sir. Kapil sir is one of my most favorite speaker and also my most favorite speaker of all our chartered accountants from India. He is no need to introduce to our chartered account community. But naam hi kafi hai. I just read one sentence yesterday that your name should reach before you reach anywhere. Just like Kapil sir is in that Kapil sir is that personality, his name reach anywhere whenever before he reach there. So I will like to introduce you in very briefly Kapil sir. He has completed more than 2,000 seminars across the India, more than 1,000 cases at appellate bodies like that, ITIT, High Court and Supreme Courts. More than 50 webinars in last 3-4 months addressing more than 50,000 professionals across India. He has addressed session at ITIT members, shared dais with various eminent jurisdiction honorable judges from Apex Courts, High Court and ITIT members, etc. He is practicing presently at Supreme Court, High Court and ITIT appearing across India. All the viewers, please send your queries in the chat box. So we will take the questions and answers at last at the end of seminar. So I welcome all of you again, and I hand over Kapil sir all session to you.
Thank you, Samir bhai.
Take the charge of session. Over to you, sir. Kapil sir.
Thank you, Samir bhai. Am I audible?
Yes, sir.
Okay, thank you, Samir ji. Chawla Saab, my elder brother, and a very religious and a very happy soul and blessed soul, whose presence always is a sort of a motivation to everyone with whom his company is there. And in absentia, our Chitle Saab, my handsome friend Anish bhai, and Soni Saab, and my good friends from Direct Tax Committee of Institute of Chartered Accountants of India, and all the learned and erudite participants who have joined me in this virtual webcast organized by Institute of Chartered Accountants of India on this. As you rightly say, that the issue now, Chawla ji, this has become now a very, very, what you say, I will say not, if I don't say disappointing situation, but I would have to say that it is a challenging situation.
Really challenging situation, yes.
So now in these challenging times, on challenging times for taxpayer Chawla ji, So it's definitely a matter of a great fight. Now you see, so many notices have come in all those cases which were once settled, by High Court decisions that these notices are bad in law, are void ab initio. Before going into this topic, because maybe many of the viewers may have heard me as Chawla Ji Institute keeps me busy with me as far as I am concerned. I am very happy that they keep me busy with these seminars, and I enjoy it a lot. That is a different matter. But I will try to start today's discussion, Samir Bhai, on a different note. If you go to Chawla Ji, you will appreciate, if we go to Constitution of India, and if we analyze there are three functions, Anish ji. There are three functions which are given in the Constitution. One is legislative function, one is judicial function, and one is executive function. Now, you can note this. These are very interesting situation कि कौन सा function कैसे होता है. Legislative action से एक बात निकल के आया, एक judicial action हुआ, एक executive action हुआ. मतलब 3 वे organs है हमारे यहाँ, legislature, judiciary, executive. और इनका अपना अपना क्षेत्र रक्षण है. मतलब if I say in English that all these 3 organs in the Constitution of India are having earmarked separation of powers. Legislature has different powers, executive has different powers, and this judiciary has different powers. Now you understand, Chawla ji, before coming to Supreme Court decision, I just wanted to pose a question, very interesting question. Because last day I was reading one Allahabad High Court order by some single judge, Justice Srivastava. Now in that case, what was happening, Samir ji, that one issue came, if there has to be conferment of jurisdiction on a particular officer for a particular act in a particular statute, it is by whom the jurisdiction is conferred. Whether judicial action can confer jurisdiction under a statute, whether executive can confer jurisdiction on itself by its own, or whether legislature is only having that competence to confer a jurisdiction on a statutory authority. And this is a very sharp point. So, the court decision was this, sir, that conferment of jurisdiction under a statute is a pure legislative function. Meaning thereby, if under income tax law, if a reopening has to be done and a jurisdiction of reopening has to be assumed, sir, then it has to be a legislative act. It has to be with the blessing of the legislature that a particular jurisdiction comes. Now that jurisdiction cannot be conferred on an authority beholds that legislative act by judiciary with due respect and by executive by itself. I hope my point is well taken note of. So, this is primarily based on separation of power concept enshrined in our holy Constitution of India. It cannot be like this that executive can confer jurisdiction upon itself by its own. Neither judiciary can confer jurisdiction on the assessing officer. I hope this point is well taken note of in the beginning itself. Now in this background, one has to read the Supreme Court order with all humility and with all humbleness. That when I come to the Supreme Court order now, Samir ji, now it has some checkered history. It has some history with itself. Now history is like this, that in 2021, in February, we had this Finance Bill 2021, sir, which replaced the old regime of Section 148 by the new regime. And the cutoff date was appointed as 1st April 2021. So beginning 1st April 2021, Finance Act 2021 said that this new set of provisions of Section 147, 148, 148A, 151 will come into operation. And till 31st March 2021, the old regime was applicable. So this change, this paradigm shift, this sea change, this epochal change came up with by Finance Act 2021, sir. And Finance Act 2021 came in March 2021, as we all know, and in this finance bill come in February 2021. Now, when all this was happening, when this Finance Act came, when all these new provisions of Section 147, 148, 148 capital A, 151 took the place of the erstwhile provisions, with effect from 1st April 2021, now there was a legislation which was already in place, that is Taxation Relaxation Law 2020, which was there due to this COVID. Am I there, sir? Honiji. And then in that, there were notifications, there were extensions, time extensions given from time to time under section 3 of the taxation relaxation law, TOLA, as we say, 2020. Now in that taxation relaxation law 2020, in section 3, there was a power given to the government and the competent authorities are that given, they can extend the timelines by way of notification, etc. I hope this is well taken note of. Now, when this Finance Act I said came, 2021, there were two notifications which were brought into operation by the central government. Wide notification dated 31st March 2021 and second notification dated, sir, 27th April 2021. So what these two notifications did, sir? These two notifications, sir, we all know, I'm just recapitulating. These two notifications, sir, Aniji, extended the time limit applicable under the old law expiring on 31st March, first to April, then to June, 30th June. So these two notifications, which were issued under section 3 of the taxation relaxation law by the government under delegated legislation, extended the time limit of old regime of section 148 from 31st March 2021 to 30th June 2021. Now, due to this time extension, due to these notifications, which became the hotbed of controversy, because 90,000 or more than that, as we read the Supreme Court order, the figure of 90,000 notices comes from there. Because it is not, one can have always a doubt where from this 90,000 notices figure came. This is given by the government to the Supreme Court of India, Justice M.R. Shah, and Supreme Court has noted in its order. So, in April in 2021, April in May 2021, sir, and June, combined these 3 months, as we understand from Supreme Court decision now, 90,000 odd notices were there, which were issued in the extended time period, this disputed time period of April, May, June. And since there were huge number of notices, as Supreme Court order says, there were 9,000 or more writ petitions filed by various writ petitioners and taxpayers across country in the various honorable high courts, challenging the validity of those notices which have been issued under section 148 old law in April month, May month and June month of 2021 calendar year. And now this attracted huge litigation and huge, that it was like a docket explosion, if I say in our legal sense, because 9,000 writ petitions, you see, and 90,000 notices. This is the statistics as given by the Honorable Supreme Court in its order. And now, when this sojourn, I say this journey started of litigation, the bone of contention, sir, if I crystallize, it was like this to save time so that we can use more time on queries, etc. The bone of contention which was crystallized was like this, sir, that whether the issuance of those two notifications, disputed notifications and controversial notifications dated 31st March and 27th April, were within the powers of the government or not to issue that notification under section 3 of taxation relaxation law, when already there is a parliament made law by Finance Act 2021 which amended the Statute Income Tax Act and new provisions replaced the earlier provisions. So this was the exact bone of contention, I repeat. Whether those two notifications which were issued under taxation relaxation law, section 3, which extended the operation of this old law of section 148, can it put in abeyance the parliament made law by Finance Act 2021? This was the question mark. This was the legal quandary. This was the conundrum. This was the riddle which has to be solved by the various honorable high courts in the country, which took so much of judicial time with due respect. And now I don't know where we are heading towards. That is why I was saying it's a challenging situation. You know, when we go on a road and that we don't know the destination of it, sometimes it creates an anxiety in the mind of any reasonable human being. So, Anish bhai, your smile speaks a lot. So that's how it goes. When these two notifications came, when this huge number of notices were issued, when the department used the old law after its expiry date, and already when new law was there by parliament made law, then I believe, as Supreme Court says, 9,000 writ petitions have been there. Now in that, you will appreciate that first decision was a Chhattisgarh High Court decision of single judge Piyush Khattooja, which came against the taxpayer. where they said ki no, this time extension was valid. This was one solitary decision which came against the taxpayer, although it was the beginning of this journey. At the beginning of this journey, I can say the experience between the beginning and now till Supreme Court. Now the happy experience starts after this Honorable Chhattisgarh High Court decision. Now, when the Chhattisgarh High Court decision was already there, the first favorable and first important decision or epochal decision which came from the Allahabad High Court, Honorable Allahabad High Court, the bench of Justice the decision authored by Justice Soumitra Dayal Singh, SD Singh. Now, in that decision, that is 439 ITR, volume page 1, you can note down Ashok Kumar Agarwal, 439 ITR, page 1. In that decision, the Honorable Allahabad High Court primarily took this position and stand that these two notifications issued under taxation relaxation law, sir, could not put in abeyance the parliament made law. So they struck down those notices and gave the liberty to the income tax department if they want to go to the new regime, then if the conditions of that law are satisfied, 148 capital A, etc., then they can use it. That was the summary that I'm saying, telling the summary of Ashok Kumar Agarwal decision, leading decision of Honorable Allahabad High Court, 439 ITR, page 1. Now, one first decision came from Allahabad High Court. So, in this span of time, Chhattisgarh High Court was one decision which came against the taxpayer, single judge. Then came the Honorable Allahabad High Court decision in Ashok Kumar Agarwal, which took this is a division bench order, double bench order, where they said that these notifications are definitely, seriously vulnerable on their validity front, because already when Parliament made law is there, Finance Act 2021, this notification cannot put in abeyance the Parliament made law, that is Finance Act 2021. Now, after this, sir, Allahabad High Court decision was one first decision favorable to the taxpayer. Then after that, we had the decision of Honorable Delhi High Court in Manmohan Kohli's case, which also was a very detailed decision, very elaborate order, where huge number of litigants were there. As I recall, more than 1300 writ petitions were there. More than 1300. More than 400 lawyers. And more than 1 month hearing. This is again that was an epochal order. Manmohan Kohli's case by Justice Manmohan. That is 15 December 2021 order, where the Honorable Delhi High Court followed the ratio or followed the judgment of Allahabad High Court and said the same thing. Ki this two notifications, sir, insofar as they put in abeyance the old law, the new law, and they extended the old law, it is ultra virus. Delhi High Court clearly hold it is ultra virus, and they gave liberty. It is noted by Supreme Court by Justice M.R. Shah in the Supreme Court decision, in this order of Supreme Court, it is noted that Delhi High Court has given liberty to the department. If they so feel, then they can go to 148 new law and 148A. And if it is done, then assessee can also come back for the writ. Challenge it if that is not in accordance with the new law. So it is not like this that Allahabad High Court did not protect the interest of the revenue. They gave the liberty to the department, in my humble opinion. And Delhi High Court also gave the liberty. And that liberty, sir, is given by other high courts also, which struck down these notices, sir. So, after Allahabad High Court, Delhi High Court, then in January 2022, sir, Haniji, we had now Calcutta High Court and this Rajasthan High Court. One of the very important orders I want to say, sir, it's this Rajasthan High Court order in case of Sudesh Taneja, sir. One must note this order, and I have said in various seminars, sir, this Sudesh Taneja's case is one of the most important and worth reading order, sir. Sudesh Taneja's case. And in that decision of Sudesh Taneja, the Honorable Rajasthan High Court Justice Akhil Qureshi has taken lot of pains to analyze that what are the core principles of Section 148 which should be kept in mind. And then following Allahabad High Court and Delhi High Court, the division bench of Rajasthan High Court, Honorable Rajasthan High Court in Sudesh Taneja also took the same path, charted the same path, Anishji, that these notices are invalid. But I want to say one thing very important, sir, Anish, by this Rajasthan High Court decision, I'm telling you, sir, this has very serious implication for today's discussion. Because when we will go to this issue and country, whether this assessment year 13, 14 and 14, 15 and 15, 16, which is the main question troubling the mind of various taxpayers and tax consultants. So this decision of Sudesh Taneja will help you a lot to try to address this query. And what is so important in this Sudesh Taneja's case, para 37. It's a lengthy order, but this paragraph 37 of this order, in my humble opinion, sir, is that point where we get that clue that department and CBDT in its latest instruction has wrongly interpreted Section 149(1)(b) first proviso. So para 37 of Sudesh Taneja, Rajasthan High Court order is one of the most important decision to my mind, sir, where this issue, where one can get this point that whether assessment year 13, 14, 14, 15 and 15, 16 are time barred or not within the meaning of section 149 subsection 1 clause B first proviso, and which is wrongly interpreted by CBDT in its instruction number 1/2022 dated 11 May 2022. Are you getting my point, sir? So this Rajasthan High Court decision by Justice Akhil Qureshi, as I know and many of the friends will be knowing, Justice Akhil Qureshi was one judge who has headed the tax bench in Gujarat for a number of years and Bombay also. And then his lordship was there in Chief Justice. He has recently retired. So this decision is penned down by Justice Akhil Qureshi, and he was equally, this decision gets beauty because Justice Samir Jain was also there. I am told that he is also he is also having very good command on accounts and taxation, Justice Samir Jain. So this decision assumes serious importance for any academician or any person who wants to learn more about 148, because this also discusses at length the rudimentary and fundamental principles of section 148 in place, sir. As I said, para 37, para 31 can also be kept in mind, sir. Para 31. And then in this decision itself, somewhere, sir, it is stated that whether 148 है नया वाला करना है, उसमें जो relied upon information का भी issue आएगा हमारे सामने निजी. That Justice Qureshi has very beautifully said कि although it is not so much stated in so many words in the new law under section 148 capital A clause B show cause notice that relied upon information has to be given, but it has to be read into the law to make it meaningful opportunity. So see the farsightedness of the learned judge. He, at that time in January 2022, when there was no challenge even to 148A was not there before them, they were old notice. But still they came out, how 149 subsection 1B first proviso has to be interpreted, A, and how 148 capital A clause B show cause notice has to be in compliance with principle of natural justice and audi alteram partem. So, in my humble opinion, I am diehard fan of Justice Qureshi. This is worth a reading order, sir. A magnum opus to my sense in locus classicus. Now, and you know, when we talk about Anish bhai that these judgments and some kind of judgments are there कि जो कभी section change भी हो जाता है, कुछ भी होता है, पर वो judgment रहता है, उसका sense रहता है, वो locus classicus बोला जाता है, उसको magnum opus बोलते हैं. So Justice Qureshi's order of Sudesh Taneja is no less than any magnum opus and locus classicus to my sense. Anyhow, I will go further in the journey. So that Allahabad came, Delhi came, Calcutta came, Rajasthan High Court, Sudesh Taneja came, then Madras High Court, Justice Bhandari's decision in Velo Technology came. And then, of lately, we have decision of this Bombay High Court in Tata Communication by Justice K.R. Shriram, and then Karnataka High Court decision by Justice Alok Aradhe. So this completes the chain of the decisions of the various high courts, sir, which came successively and consecutively in the favor of the taxpayer, striking down and holding these notices issued in the extended period of April, May and June month to be ultra-virus, to be illegal, to be unlawful, as they are issued in that period when already old law has been expired. So, we have to keep this in mind that Allahabad, Delhi, Rajasthan, Calcutta, Madras, Bombay, Karnataka. So at least, and you will also see from Honorable Supreme Court decision, they have given a table of the cases where 8 High Court decisions are mentioned at paragraph 2. So, although Supreme Court was having SLP against Allahabad High Court order, but it was brought to their notice, Lordship's decision, notice that various other High Courts, including Delhi High Court and other High Court, have taken the same position. So, Supreme Court decision, Anishji, was very clearly said that it will be applicable to Pan India, and all those cases will be also now governed, whether it is Delhi High Court or any other High Court. So, the Supreme Court very clearly made it is applicable Pan India, and it will govern all those cases also where writs are pending, and it will also apply to those cases which are already decided, even though SLP is not there before the Supreme Court. That is very clearly written by Justice M.R. Shah in his order. So now, what I say, now in this background, short background and prefatory background, now the Supreme Court, how this battle now reaches to Supreme Court, Department filed one SLP, sir, special leave petition, against Allahabad High Court decision. That is now the decision of, the name of the decision which we are discussing today is Union of India versus Ashish Agrawal, 4th May 2022 order. Now this is the decision of Supreme Court of India, which is given in the case by double bench in the case of Union of India versus Ashish Agarwal. Now, if I try to analyze this decision from a, from a very objective sense and a balanced sense, then it is like this. I believe this decision is primarily preordained, or is primarily driven by Article 142. Because in opening itself, the Honorable Supreme Court Justice Shah cleared that this decision is decided given some kind of via media. And this he has said very categorically, to be noted in paragraph 2.1, page 7. He has very clearly said in para 2.1, page 7, that we are writing this judgment. Rakesh ji, namaskar. We are writing, I am seeing him. Para 2.1 is the decision, and in the decision of Supreme Court, it is primarily, is thought process is governed by Article 142. Now, how Article 142 came into place? Because I was, sir, one of the small part in the proceedings. Because our chamber also filed one intervention application before the Supreme Court on behalf of one of the SSC who got favorable decision from Delhi High Court to intervene in the matter. So I was part of the proceedings of the Supreme Court completely from beginning till end. So I was there in the first row to witness everything what has happened. In my humble opinion, the starting point which the revenue took was this, sir. The department read the decision of Delhi High Court before the Supreme Court, sir. Mr. ASG, the Venkatraman Sahab, read before the Honorable Supreme Court, ki sahab, we will make our argument from the based on Delhi High Court decision. Although it is another matter that SLP was filed against Allahabad High Court. So what Mr. ASG opened the argument from revenue side, who are the appellant? Revenue was appellant in this matter. So revenue opened up the argument like this, ki sir, Delhi High Court Manmohan Kohli's case, in one of the paragraph, Anish Bhai says that this is a procedural section and any change in the procedural section would be applicable to the pending proceeding also, and it will apply retrospectively. So that paragraph was, ingeminated by the revenue before the Honorable Supreme Court from ASG side, that once this is held to be a procedural change, although it was not the only point which Delhi High Court said. Delhi High Court said lot many other things also. Yes, when they gave reasoning, it was one of the reasoning in the Manmohan Kohli's case, since this change which happened from 1st April 2021 in section 148, since it is a procedural change, it will apply to all the proceedings which are pending proceedings even, and it will have a retrospective implication. So now what department said, sir, even if we have procedurally made a mistake, then it should not haunt us. It should not kill our remedy. It should not be detrimental to revenues or exchequer's interest. That was how this entire thing diverted to that thought process. Now to Article 142 line somewhere. Delhi High Court said since it's a procedural change, and so it should be, now procedure is the handmaid of justice, they say. Now procedure should be for justice to the department and justice to the SSC. That is how revenue brought its argument before the Supreme Court, sir. Although I have said you that this is not the, sorry, with due respect, this is not the only way, or this is not the correct way, fully correct way to appreciate the sense of the provision, sir. Because, Anish Bhai, you will appreciate that, as I told, section 148 confers jurisdiction on the AO to reopen an assessment. And jurisdiction, I have already told in the beginning, is a matter of legislative act. It cannot be conferred by judiciary or executive. So, keeping that in mind, separation of power wala point, constitutional norm, cherished norm. Now, just saying it is to procedural change, then I believe it is not appreciating the sense of jurisdictional provision, jurisdictional point. In law, when we read any provision, sir, there is a special significance of what is called as jurisdictional issue and what is called as non-jurisdictional issue. In my humblest and little and limited understanding, this 148 notice is a jurisdictional point. To de-escalate and to say it and to reduce it to just procedural level, I'm sorry, it is not an honest treatment to the 148. Because nature of proceeding under 148, when no 148 notice is given, is it a mere procedural notice? It is not a jurisdictional notice. I'm asking a question to myself. So, anyhow, you will say, Mr. Goyal, now what happens? The Supreme Court ka order abhi aa gaya hai. Anyhow, this is an academical point and also an important issue. Whether jurisdiction can be, how jurisdictional issue and how jurisdictional point and how jurisdictional act has to be appreciated. Or how flaw in a jurisdictional act has to be taken up. In my humble opinion, 148 notice remains a jurisdictional issue, sir. And there are Supreme Court decisions by larger bench, sir, which have hold section 148 is a jurisdictional notice. If I am to tell one decision, you can note down Y. Narayan Chetty, 3-judge bench, Supreme Court of India, 35 ITR, page number 288. Long back said that 148 notice is not merely a procedural notice, it's a jurisdictional notice. That is Y. Narayan Chetty, 3-judge bench, Supreme Court of India, 35 ITR, 288. So, now, revenue said to the Supreme Court, the Honorable Supreme Court, ASD साहब के साथ this is a procedural change बोला, तो अभी हमारे को something should be done to save the, what you say, to salvage the situation. To give remedy to the department. These all words are used by Supreme Court judgment also. I'm not giving it from my side. They are all part of now order also. That to salvage the situation or what you say, to give remedy to the revenue or to what you say, to prevent the loss of exchequer. These are the terms with due respect attracts lot of academic attention also. So now when this limited argument was taken up, Manish bhai, nothing about taxation relaxation law, nothing about TOLA, nothing about section 3 TOLA notifications, time extension. And to my utter surprise, when CBDT brings all these things, I'm surprised how this comes up, reincarnates, how this recircuits. When before Supreme Court department's case was also not that, how this has come up. Nowhere an inch of word was spoken. If one remembers and recalls in hindsight what happened and transpired in Supreme Court, there was no single whisper of word on TOLA and the notification issued under there and on this time extension. Only thing which was debated and argued was how to now remedy the situation, how to salvage the situation, how to prevent the loss of the exchequer. And then this thing diverted to Article 142 in a what you say, in a very different fashion. See, I am not an expert of Constitution of India, A. And I am not having very good knowledge of constitutional provisions. I cannot command that. And secondly, this Article 142 is something to be confabulated and what you say, cogitated by someone who is a constitutional maestro. So, but my little limited knowledge says about Article 142 that this is a power given for complete justice. And it has to be used in exceptional and rare circumstances. It cannot be used in a routine manner. That is a settled principle. It is a complete justice power, plenary jurisdiction of Supreme Court. So, but anyhow, Supreme Court felt this is a fit case in its own wisdom, that yes, there is lot of loss of revenue and exchequer and there is no remedy now left to the revenue and it is injustice to the revenue. So they brought, as the order says, that Article 142 is coming into place. So when you read a judgment which is governed by Article 142, how its ratio decidendi has to come, it has to be kept in close mind. And secondly, when all these things were debated, argued and contested in a limited manner and a very, very, what you say, confined manner. So, Honorable Supreme Court, as we read, Anish, by this entire Supreme Court order, paragraph 7 and paragraph 8 are very important. Which is the main decision, जो उसमें अभी SCC में जो आया उसका paragraph कुछ और हो सकता है, but the main decision का paragraph है 7 or 8. In paragraph number 7, in paragraph number 8, the Honorable Supreme Court has very clearly said, sir, let us come to what Supreme Court holds in fine. Supreme Court says in para 7, the High Courts were right. That yes, this change made by Finance Act 2021, sir, it is benevolent change. It is benevolent change. I will read. Para 7, what it says. Thus, the new provisions substituted by Finance Act 2021 being remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interests of the assessee as well as the same being in public interest means that it's a remedial provision, it's a benevolent provision, it's a substituted with aim and object to protect the rights and interests of the assessee as well as being in public interest. Then High Court say, the Supreme Court says, Honorable, the respective High Courts have rightly held that benefit of new provisions shall be made available even in respect of the proceedings relating to past assessment year, provided notice under section 148 has been issued on or after 1/21, 1st April 2021. Meaning thereby they say, there the Supreme Court has given its imprimatur and approval to all the High Court decisions which they have noted otherwise in opening paragraph 2. That all our decisions are approved by the Supreme Court, expressly approved, not impliedly approved. insofar as they hold that after 1st April 2021 cut-off date, the new law notice has to be issued, not old law. Am I clear about it? This is locked here. This is not unlocked anywhere else then. Para 7, then the next line says, we are in complete agreement with the view taken by various high courts in holding so. Para 8 says, the opening para 8 says, this is very important. However, at the same time, the judgments of several high courts would result in no reassessment proceedings at all, even if the same are permissible under Finance Act 2021 and as per substituted section 147 to 151 of the Act. They mean to say, due to high court judgment, it might be possible that now 148 could not be taken in the new law also. The revenue cannot be made remediless. This is where the point of debate comes, and some people have different thoughts also and sentiments. The revenue cannot be made remediless, and the object and purpose of reassessment proceedings cannot be frustrated. I have already given my sentiment in academic and most humble and most respectful manner that this may require further debate and might be, if in case this matter goes to higher bench or larger bench or constitutional bench, this point has to be debated. Whether revenue cannot be made remediless and the object or purpose of reassessment proceedings cannot be frustrated can be a ground to invoke Article 142. All these things. It is true. Now, Anish by next line says it is true that due to a bona fide mistake and in view of subsequent extension of time by various notifications, bona fide mistake. Now, Supreme Court says it might be a bona fide mistake. This is also a very interesting word. The revenue issued the impugned notices under 148 after the amendment was enforced with effect from 1/21 under the unamended section 148. Now, kindly note this line, sir. Please take note of para 8, page 26. This very important line, Anish, but says, in our view, the same ought not to have been issued under the unamended act, same ought to have been issued under the substituted provision of 147 to 151 of Income Tax Act as amended by Finance Act 2021. Iska kya matlab hua? What does this mean? It means Supreme Court is very clearly saying here that whatever notices were issued by the Income Tax Department in April month, May month and June month of 2021, they notices ought to have been issued under the new law. Am I there? So this debate of which CBDT inspection has now brought कि नहीं साहब ये टोला वाला कहां से आ गया फिर तो सुप्रीम कोर्ट ने गलत लिखा है. Then Supreme Court judgment is wrong. Then we are rewriting Supreme Court order. Sorry. Are we saying that in that process when Supreme Court has once hold by one line or sorry one at one place that old law could not have been applied after 1st April 2021, by what means TOLA and extension notification survive now? They are not writing in para 7 only. They are repeating in para 8. I am saying this. That notices after 1st April ought to have been issued under the amended provision of Finance Act 2021, not under the unamended provision. That is clear. Page 26, para 8 and para 7. In my respectful, humble and sincere opinion, this locks that point that high courts were right. TOLA notification was wrong. Time extension was wrong. And notices should have been, ought to have been issued, use the same phrase, ought to have been issued under the new law. Now comes the mercy, or sorry, what you say. Now comes the Supreme Court lenient view towards the revenue. Supreme Court says the High Court went wrong in quashing the notices. They ought to have converted the notices from 148 to section 148 capital A. In the same paragraph 8, they have said, the lordships have said, that while High Court, when they say that these notices were wrongly issued under the old regime, they, while instead of quashing, they should have changed the notice. That is why I am saying this is again a very serious issue. Whether this act, by judicial act, can you convert a notice from the one provision to the other provision? Or it should be done by legislature, or it should be done by executive, or it should be done by judiciary. I am sorry, I'm saying in a very humble manner. Having very little understanding, having very limited understanding, having hollow understanding. You give me all respect, but point is this that साहब अभी तो ये decision आ गया है. अब बोलेंगे उसमें क्या हुआ गुल साहब, अभी आगे रिव्यू के लिए जा सकता है नहीं हो जा सकता, वो एक अलग भविष्य का बात है. अभी तो हमें किसी को नहीं पता भविष्य में क्या होना है. What is happened to future? We can't astrologe. But anyhow, yes, this is a very, very important issue, sir. When a jurisdiction has to be conferred on a particular authority under a statute, it has to be conferred by legislature, question mark. It has to be done by judiciary, question mark. It has to be done by executive, question mark. In my understanding, our Constitution of India is very clear, sir. It is legislature only. And that is why, Anish bhai, I just told that Allahabad High Court order. That jurisdiction cannot be conferred otherwise. Anyhow, now Supreme Court says, why Supreme Court says, Supreme Court has written that there may be they say there appears to be a genuine non-application of the non-amendments. Now please note this line, there appears to be genuine non-application of the amendments as the officers of the revenue may have been under a bona fide belief that amendments may not yet have been enforced. I'm sorry. See, as I was there in the court, nowhere revenue pleaded that this was a bona fide mistake. Or I can say in humble words, chaste words, that it was never the case of the revenue before the high courts that this was the innocuous act or inadvertent, what you say, or a fortuitous and accidental, some kind of a, what you say, fortuitous thing. Rather, they hotly contested and they say, we are right. We are right in issuing the notifications. We are right in issuing the old law notices. We are right in not showing obeisance to the law made by the parliament of the country. What is this obeisance? I don't know. I am not understanding. The obeisance is towards parliament made law, or obeisance is towards the notification issued by central government. Anyhow, now Honorable Supreme Court says in the order, therefore instead of quashing and setting aside the reassessment notices, High Courts ought to have passed an order construing the notices under as those deemed to be issued. Now kindly appreciate Anish Bhai as an academician, humble academician. I say this paragraph is definitely difficult to digest. As far as basic rudimentary principle of law is concerned, how you are converting one provision of notice to the other provision of the notice? What is the constitutional backup for that? What is the basic jurisprudence already settled? It is not like this 148 income tax law has first time reached the Supreme Court, sir. I'm sorry. If you go to commentaries of Prithvisarya Chaturvedi, one of the largest thick volume, and Mr. Datar commentary now, Kanga Palkiwala, any commentary, any leading commentary on income tax 148 sections, sir, you will find that this has been, there has been series of judgments of Supreme Court which has debated, analyzed the nature of 148 proceedings, sir. Anyhow, the Supreme Court has said in para 8, yes, these notices ought to have been issued under the new law after 1st April. High Court were not right in quashing and setting aside the notices. They should have converted it to and deemed to have been issued under the new law. Now, while saying so, I just draw attention of my all viewers, and it's a very important point I'm telling you, sir. Now, when they have said it, what they have said on page 27, they say revenue ought to have been permitted to proceed further with the reassessment notices as per substituted provision of section 147 to 151 as per Finance Act 2021. Means that when they say, the Supreme Court says that it ought to have been converted, they were very clear in their mind that new regime has to be strictly complied with. And new regime of, kaunsa new regime? Which new regime? Entire new regime. Are you getting my point? Entire new regime means new 147 section, new 148 section, new 148 capital A section, new 149 section. This is the most important point. I am not saying anything from myself, sir. I will repeat. They say in para 8, page 27, revenue ought to have been permitted to proceed further with the reassessment proceeding as per substituted provision of section 147 to 151 as per Finance Act 2021. Subject to compliance of all the procedural requirements and defenses which may be available, please note this line, which may be available to the assessee under the substituted provisions of section 157 to 151 and which may be available under Finance Act and in law. Sir, this sentence, Anishji, is very clear. It says, even if these provisions are to be converted as Supreme Court opines to the new regime, then they have to be strictly in compliance with the mandate and command of section 147 to 151 as amended by Finance Act 2021, that is FA 2021. And all defenses which are available to the assessee. Here there is no talk about revenue, sorry. The confusion is added because when we read in para 10 and when we go to para 10.4, where they say that as available to the assessee and revenue also they have added the word. So please, sorry, this is not the way. I have to read a judgment like a whole. In my humble and respectful submission to my viewers, para 8 is very clear. The defense is defense to the assessee, sir. We cannot rewrite Supreme Court order, sir. We don't have that audacity and impunity to rewrite the Supreme Court decision. So, in my opinion, para 7 and para 8, 4-5 principles comes out, sir. First principle is this: all those High Court decisions are given approval on principal ground that notices ought to have been issued under the new law, cannot be issued under the old law after 1st April 2021. Second point, Supreme Court says that while holding that they ought to have been issued under the new law, it is very clear they have to be strictly in compliance with the entire new regime of Section 147 to 151 as amended by Finance Act 2021, sir, including Section 149 new law. And there is no whisper in all this para 7 and para 8 about taxation relaxation law 2020 and TOLA and all those notifications, which to my point is extraneous and irrelevantly brought into the place. Now you can come to para 10. Para 8, there is a draft thing they proposed. Para 10 is the confirmed directions of the Supreme Court, which has now been interpreted by CBDT in its latest instruction dated 11th May 2022. Now, para 10, if I summarize, Anish bhai, quickly, very quickly, what it says? Para 10 says, ki sahab, this judgment, which now, these appeals of department are partly allowed. What is partly allowed? Partly allowed means para 7, they say, they are principally agreeing with the High Court, but they are converting notices from 148 old law to new law. So that is why it is partly allowed. As we know how to interpret the word partly allowed, I believe all are clear about it. Para 10, Supreme Court decision says, Samir bhai, partly allowed. Now, in para 10, there are 4 significant directions, sir. Now, first important point they say, कि साहब all these notices which are issued within the चिटले साहब welcome आपका स्वागत है भाई साहब
नमस्ते नमस्ते कपिल भाई थैंक यू
आप गुवाहाटी अकेले अकेले घूम रहे हैं हमारे को तो लेकर ही नहीं गए
आपको ही लेके जाना था अगर आपका तबीयत ठीक से नहीं कर रहे हैं
प्लीज प्लीज टेक आई एम वेरी
आपका तबीयत ठीक नहीं चल रहा है मैं तो ठीक हूँ
वेलकम चित्रे सर I acknowledge the presence of Central Council member and the Directors Committee Chairman, C.V. Chitre, sir. Welcome, sir. On behalf of all the participants.
Thank you.
Over to the point, sir.
Thank you, sir. Thank you. So, I was just submitting the para 10 ka first point, sir. Chitle sahab, we were discussing Supreme Court order. So, now we have come to para 10. Yeah. Para 7, para 8 I have explained. And the background of the decision I have explained, sir, completely. Now, para 10 says, sir, it is a partly allowed appeal. And in that, the Supreme Court has given 4 significant directions. One of the first important direction is this. And this is under Article 142. They are giving. They are using their plenary power of complete justice. And that is what they have said, that lordships have said that we are doing to give remedy to the revenue and to prevent the exchequer loss. Okay. Now, it is another matter debate. I have already said, Chitle Sahab, some various chartered accountants and our fellow colleagues have asked me, Mr. Goel, whether it was a fit case for use of Article 142C. I have already said a humble point. I am nobody to comment upon it. But yes, our scholastic or what you say, academic understanding says that no, Article 142 should not have been used just for sake of protection of revenue. Because that is like this, that if I am going to a court, Samir bhai, and I am asking for justice, that this is wrong happened to me, then court says, no, if it is a wrongly applied provision, let us hunt which could be the right provision. Is it the way a petitioner will go to the High Court under a writ jurisdiction? I'm sorry, I ask a question, humble manner as an academician. So anyhow, this answers that query, whether it could be a case for Article 142, and even Justice Amar Shah himself in Supreme Court has said that Article 142 cannot be applied just for sake of it and just for equity. You cannot supplant the law. When there is a statute in place, you cannot go to Article 142 to replace it. That is what Justice Amar Shah in a one order of the Supreme Court, while authoring a order, he has himself said and negated application of Article 142 to bypass the statutory mandate. And those decisions are there. So anyhow, now it is a larger debate or an academic question now, more of an academic question, whether Article 142 could have been resorted as it has been used in the present case for sake of giving remedy to revenue and for sake of revenue loss or exchequer loss. And exchequer loss is which exchequer loss? अभी तो 148 का नोटिस आया था, असेसमेंट तो हुआ नहीं, वो exchequer loss कहाँ बना? ये भी क्वेश्चन हमारा चार्टर्ड अकाउंटेंट भाई पूछ रहे हैं, दोस्त पूछ रहे हैं. चलिए, Para 10 का पहला डायरेक्शन सर. These notices which are issued from 1st April to 30th June are construed as notices under 148 capital A clause B. I repeat, the notices issued under the old regime from period of 1st April to period of 30th April will be construed as notices issued under the old new law under 148 capital A clause B. This is flowchart point number 1. Point number 2. Supreme Court says whatever they have with them, department, in name of reason to believe, information, etc., blah, blah, blah. They will now, process it and give it to the taxpayer under 148 capital A clause B as per Supreme Court directive to the taxpayer as information. What information suggesting escapement of income? You will say how Mr. Goel reason to believe will be transformed into information suggesting escapement of income. Please don't see. I can answer only that thing which is in my capacity to answer. अभी डिपार्टमेंट तो करने भी लग गया, वो दे भी दिया सब लोगों को भी, तो बहुत नोटिस में आ गया इन्फॉर्मेशन. वो कैसे आया है? वो तो ऐसे आया, सप्लाई ऑफ इन्फॉर्मेशन एज पर ऑनरेबल सुप्रीम कोर्ट डिसीजन, और वो इन्फॉर्मेशन के नाम पे अनिश भाई से हंस रहे हो, 2 लाइन आ गया. बताइए क्या इन्फॉर्मेशन हुआ? एज यू राइटली लाफिंग and you rightly giving this emoji, but it reflects a lot. See, now it is, sorry to say, Supreme Court direction was not this, that this sharing of information has not to be meaningful and effective sharing. It has to be effective, sir, because it has to be in compliance with 148 capital A clause B mandate. Why otherwise Supreme Court have wrote that within 30 days you have to complete this exercise for Pan India cases and provide information to the taxpayers. Now in name of supply of information, Sameer bhai, abhi wo information kya aa raha hai? वो 2 लाइन लिख के आ रहा है. 2 लाइन समझते हैं आप? 2 अल्फाज लिख के आ रहा है, मतलब इट इज एज लिमिटेड एज. उसको समझ पाना किसी भी मेरे जैसे आदमी के लिए बड़ा मुश्किल है सर. फॉर मी इट इज वेरी डिफिकल्ट टू अंडरस्टैंड, एंड आई से इट विद ऑल ह्यूमिलिटी. आई कांट अंडरस्टैंड इट. वो तो लिखा है कि इंफॉर्मेशन आ गया, अभी आपका एस्केपमेंट हो गया. भैया उसको इंफॉर्मेशन कहां से आया? वो रिस्क मैनेजमेंट स्ट्रेटेजी का क्राइटेरिया फुलफिल करता है या नहीं करता है? वो रिस्क मैनेजमेंट स्ट्रेटेजी नहीं पता आज तक हमारे को. मैं तो कई बार समझने का कोशिश किया हूं कि वो जो नया लॉ है उसमें 148 का एक्सप्लेनेशन 1 है जिसमें रिस्क एंड मैनेजमेंट स्ट्रेटेजी का बात है. वो रिस्क मैनेजमेंट स्ट्रेटेजी के तो दर्शन आज तक हमें हुए नहीं चिटले साहब. वो डिपार्टमेंट तो बताने को तैयार ही नहीं है रिस्क मैनेजमेंट स्ट्रेटेजी कैसे बनी, उसका क्या कंटोर है, वो बैलेंस्ड ऑब्जेक्टिव तरीके से बनी नहीं बनी, और उसको बनाते वक्त उसका क्राइटेरिया क्या है, और वो जो आज इंफॉर्मेशन आप मुझे दे रहे हो वो उस रिस्क मैनेजमेंट स्ट्रेटेजी के हिसाब से कंप्लायंट है या नहीं है, ये कहां सुनिश्चित किया गया है? वेयर इट इज एंश्योर्ड.
लोगों को क्या,
सॉरी सर, यस,
आरटीआई करना चाहिए क्या लोगों को?
नहीं,
आरटीआई से मंगवा ले.
नहीं, पर चिटले जी, मैं इस पे एक बड़ा लार्जर इशू है. आई वांट यू ड्रॉ योर अटेंशन सर. मैं कल परसों से आई वॉज देयर इन राजस्थान हाईकोर्ट चिटले साहब, and I was having one rate, and I am telling my viewers to pay attention to my words. बहुत इंपॉर्टेंट चीज मैं बताने लगा हूं सर. I went to Rajasthan High Court for my cases of 148A rate. There was one writ petition, sir, Maya Rathi. My friends can note the name of this case, Maya Rathi. And Chitle Sahab, it is fought by, it is argued by our good friend, Mr. Vedant Agarwal, the son of Satish Gupta ji, our past Central Council member. And he has pleaded this case before the bench of Rajasthan High Court, Acting Chief Justice Maninder Mohan Srivastav and Justice Sameer Jain. And I am telling about this development dated 23 May 2022, 23rd May 2022, 2-3 days back. What was the issue, Chitle Sahab, in this case? This Vedant Bhai in Maya Rathi case challenge the constitutional validity of section 148 explanation 1 and proviso. Ki sahab, they have made this explanation in a faulty manner. And this itself requires constitutional scrutiny whether this test of information suggesting escapement of income under 148 section, its proviso and explanation is constitutionally right or wrong. I am happy to share that this Rajasthan High Court has issued the notice on the petition of the SECI and asked the Government of India, Union of India to file its reply to justify how this new explanation in 148 is constitutionally not arbitrary, and as per Article 14 it is a right law. If I go deeper and dive deeper into this, now this is a very important development, Maya Rathi versus ITO. The interim order is dated 23rd May 2022, where constitutional validity of new law has to be tested now before Rajasthan High Court. Now what I say, Ranishji, it's a different perspective. Chitle Sahab, now you see, read section 148 explanation 1. It says for the purposes of this section and 148A, the information suggesting escapement of income, means so and so. First clause says any information, I will read that line. It says, sir, any information, it's a very different line. Any information in the case of the assessee for the relevant assessment year in accordance with risk management strategy formulated by board from time to time. Sir, first my question is this, where is this risk management strategy defined in the statute? How legislature has delegated this power to the board without defining risk management strategy and its broad guidelines, and this kind of delegation is constitutionally valid or not? Are you getting my point? This is a very serious question. कि आप लेजिस्लेचर एक पावर दे रहा है बोर्ड को कि वो रिस्क मैनेजमेंट स्ट्रेटेजी बनाएगा, और रिस्क मैनेजमेंट स्ट्रेटेजी जो बनेगी उसके बेसिस पे इंफॉर्मेशन फ्लैश होगी या बेसिस बनेगा 148 का. And I am humbly submitting what is the basis of formulation of this risk management strategy question, whether it is within the competence of the legislature to delegate this kind of omnibus power to the CBDT to formulate the strategy. This is a moot point. And why not till date, in name of transparency and public transparency, this is being shared with the in public domain? Where is this? And when lakhs of notices are already issued on basis of 148 and risk management strategy, I am sorry. Chitle sahab, already spent so much notices. आपने भी मेरे इतने सेमिनार करा लिए साहब, बट ये रिस्क मैनेजमेंट स्ट्रेटेजी के तो दर्शन हो ही नहीं रहे. ये कैसा, ये ऐसा लग रहा है कि जैसे भगवान विष्णु और भगवान ब्रह्मा विष्णु महेश सबसे ऊपर का कुछ चीज है सर. चलिए, इससे मेरी वो बात आपको समझ में आएगी कि रिस्क मैनेजमेंट स्ट्रेटेजी के डेफिनेशन नहीं है, रिस्क मैनेजमेंट स्ट्रेटेजी का गाइडलाइन नहीं है, रिस्क मैनेजमेंट स्ट्रेटेजी ही नहीं पता है हमारे को, और सब कुछ रिस्क मैनेजमेंट स्ट्रेटेजी कर रही है. और जब हम सुप्रीम कोर्ट से वो जो पुराना वाला नोटिस है वो नए लॉ में कन्वर्ट हो रहा है, और उसकी इंफॉर्मेशन आज हम मुझे आ रही है, तो मुझे ये भी नहीं पता चल पा रहा है, मैं चेक नहीं कर पा रहा हूं एज एन इफेक्टेड पर्सन हनी जी, कि क्या वो जो इंफॉर्मेशन मुझे आज दी गई है वो इस रिस्क मैनेजमेंट स्ट्रेटेजी के हिसाब से सही थी या नहीं है. आप नोट कर रहे हैं चेकलिस्ट का पॉइंट नंबर 1 कि when the Supreme Court judgment is now implemented by the government and this income tax officials, is it objectively ensured that information falls in this particular bracket of risk management strategy formulated by the board from time to time? Explanation 1 to 148 clause 1. So I hope my point is taken off. Supreme Court says old notice under 148 will be construed as new notice under 148A. They have dispensed for one time the inquiry under 148 capital A clause A. Prior inquiry has been dispensed as one time measure. Third, they say that entire information which is available with the department. Now please note, Anish bhai, whenever this information is practically coming to us nowadays in humongous manner and gargantuan manner, in my humble opinion, that information is a very, very limited information. Firstly, it is not complete information. Secondly, that information is so narrow and so nondescript that it is very difficult for any reasonable person to make out what is the case against him. So, sir, I should always ask Anish bhai whenever I reply to these notices that please give me first complete relied upon information. I hope my point is well taken by my viewer Chitale Saab, that when the Supreme Court judgment is applied by the AOs and information is shared and that information looks like that it is not complete information, then a request should be made, a preliminary request should be made that complete relied upon information must be confronted, shared and provided and purveyed to the taxpayer. Now, Supreme Court says all these exercise of giving information has to be done within 30 days of the order. In my opinion, Hanish bhai, that deadline is a strict deadline. If this deadline is missed, in my opinion, many friends have asked me कि गोयल साहब अगर इस पॉइंट जैसे किसी ने चिटले जी पूछा कि अभी नहीं मिला तो वो फिर तो उसको तो सर मोक्ष मिल जाना चाहिए, गति मिल जाना चाहिए, या उसको राधे राधे सीताराम हो जाना चाहिए. सर मैं ये नहीं कह रहा ऐसा हो, मेरे से पूछा लोगों ने, मिस्टर गोयल टेल अस इफ दिस इंफॉर्मेशन डज नॉट कम विद इन 30 days, कैन वी हैव नाउ proper sleep or we can feel relaxed? In my humble opinion, yes, because Supreme Court judgment gives strict deadline. It has to be followed word by word, inch by inch and word by word, sir. If that information does not come in any case of notice under old law of 1st April to 30th June, then Hanish ji, that goes. In my opinion, the AO will become functus officio. I hope this word is noted, functus officio. So Supreme Court says first this notice under old law will be construed as notice under the new law. Then the relevant information in the possession of the AO will have to be purveyed to the taxpayer within the 30 days of the judgment of the Supreme Court. And in my humble opinion, that information has to be shared properly, completely, transparently and fairly, so as to make it meaningful sharing of information. It cannot be like this that they have kept some things with themselves in the sleeves and something is shared. Now, it is our duty also to point out if it looks like that it is not complete information or something, as I also say, that whether this information comes in the compliance with the risk management strategy, that point has also to be taken note of in the replies to be submitted. Now what Supreme Court says, within 15 days. Sorry, yes, sir. Yes, sir.
When this information received, should we also say that, also demonstrate that it is within the parameters of risk management strategy?
Absolutely, Chitle sir, because otherwise it makes it all becomes upside down. What is the fun of getting to transmit it to new law? Because new law has to be followed inch by inch. Now you cannot say कि हम नया law में भी Supreme Court ने में आने का बोला तो भी हम पूरा उसको new law को follow नहीं करेंगे. How is this possible? I'm sorry, उनको तो पूरा 148 explanation 1 को पूरा करना है सर. At operative time, I hope and it's the right point. और वो हमारे को checklist का एक point बनाना चाहिए कि रिलाइड अपॉन इंफॉर्मेशन पूरा मिल रहा है नहीं मिल रहा है, वो रिस्क मैनेजमेंट स्ट्रेटेजी वाला क्राइटेरिया का हिसाब से पूरा हो रहा है या नहीं हो रहा है. फिर आगे बढ़ते हैं सर. When I will file this reply in next 15 days, Supreme Court says कि the SEC can file the reply, which is reply under 148 capital A clause C. That reply can be filed by the taxpayer in pursuance to the sharing of information within next 15 days. Now there is a very serious point, Chitle Saab. The CBDT in its instruction dated 11th May 2022 in para 6.1 and 6.2, I'm saying in very summary sense. They have said this assessment year, इसमें 4-5 assessment year आप note कर सकते हैं आप सब सर. AY 13-14, 14-15, 15-16, 16-17, 17-18 and 18-19. I believe 6 years are mainly involved. और उसमें भी main है 13-14, 14-15, 15-16. Now, to my mind, Chitle Sahab, all these years are time barred. There is lot of debate going in our practical circles. Maybe some other scholar and other learned erudite speakers have a different view. I humbly respect that, but my humble view I will share, sir. Assessment year 13-14, to my humble opinion, as per section 149, 1B new law, Finance Act 2021 wala, 149 1B. First proviso, it should be time barred. Assessment year 13-14 is time barred on 31st March 2021. Although it was time barring on 31st March 2020, but 1 year was extended by TOLA in the act. Are you getting my point, sir? So Chitleji assessment year 13-14 got time barred on 31st March 2020-21. And assessment year 14-15 also got time barred on 31st March 2021. I'm saying I'm reading it on the basis of my humble reading on section 149 subsection 1 clause B first proviso. That these 2 years are very clearly time barred on 31st March 2021, and in new law there should be no proceeding at all in my humble opinion on the same, and CBDT instruction to my mind dated 11th May 2022 is ultra virus, is unconstitutional, is invalid. And I say this on the basis that CBDT brings again extension notification. As I have said, this is wrong. Extension notification have no role now. In new law, when we read time limitation section, Anish Bhai, section 149 1B, first proviso, it simply says, I will read because it is a matter of very serious debate. 149 1B, first proviso, to be fair to the point, it says, provided that no notice under this section 148, new section, shall be issued at any time. First they say at any time in a case for the relevant AY beginning on or before 1/4/2021, 1st April 2021. Means that no notice in the new law section 148 will be issued for AY beginning on or before 1st April 2021. When? If a notice under section 148 could not have been issued at that time. Now another word used is that time. Earlier it was any time. That provided that no notice shall be issued at any time. Now they say, if a notice under section 148 could not have been issued at that time on account of being beyond the time limit specified under provision of clause B of section 149, as they stood immediately before the commencement of Finance Act 2021. Simply put, as I told Sudesh Taneja, Rajasthan High Court, para 37, the meaning of this proviso is this, sir, that if a notice has to be issued under the old law, notice has to be issued under section 148 in the new law. At the time when that notice under the new law is issued, it will be checked. अगर वो assessment year 1st April 2021 से पहले वाला है, तो what will be the check in proviso? That whether that notice could have been issued under the erstwhile hitherto provision of 149 1B or not. Meaning thereby simply put कि जिस दिन at the time when the new law is enforced, 148, whether there is time limit left under the old law. In my opinion, sir, 13, 14, 14, 15 got absolutely time barred on 31st March 2021. This is my humble and personal opinion. And secondly, in my opinion, assessment year 15, 16 also got time barred on 31st March 2022. By this way, as I am reading it. And I am supported by one Rajasthan High Court decision I have told, Sudesh Taneja, para 37. Another I am supported by this, there is a CBDT instruction which you can all note, CBDT instruction dated 10th December 2021. In this instruction, sir, CBDT instruction dated 10 December 2021, para 5 and para 5.1, Anishji, the Honorable this CBDT in its own instruction dated 10 December 2021 has said how to read section 149(1)(b) and how to see whether a particular year is time barred or not. This instruction was issued, all my viewers will recall, I have already also discussed in DirectX committee platform. The purpose of this instruction was this, Anishji, that when new law is to be implemented in first time, that it was a guidance to the entire income tax officer in the country by CBDT, ki how assessment year 15-16 should be reopened and how 18-19 should be reopened. So in this instruction, Chitle Sahab, even CBDT itself opined indirectly and constructively ki sahab AY 15-16 will get time barred on 31 March 22. तो सर ये वाला इंस्ट्रक्शन जो अब आया है और आप उस वाले इंस्ट्रक्शन को दोनों को एक कंपेयर करके देखिए, मेरे हिसाब से तो कोई रिकंसिलेशन हो नहीं रहा है. Anyhow, Sudesh Taneja, para 37, Rajasthan High Court, CBDT instruction dated 10 December 2021. And third, I want to say my various viewers which will be there will remember, Chitle साहब आपको भी याद आएगा कि एक सुप्रीम कोर्ट का बड़ा इंपॉर्टेंट फैसला होता है, हम लोग उसको बहुत यूज करते हैं. अच्छा, I am just telling the citation of Sudesh Taneja. Please note the citation of Sudesh Taneja is 442 ITR 289. 442 ITR 289. Sudesh Taneja citation. And I am telling another point now on time limitation 149(1)(b), sir, that this 13, 14, 14, 15 and 15, 16 are time barred. There is a Supreme Court ruling, Chitle Sahab, in KM Sharma case, Supreme Court of India, KM Sharma 254 ITR 772. You can note down, it's a very important order. 254 ITR 772. What it says, there is a jurisprudence, Anishji, that if a particular action gets time barred at a particular point of time, when the new law comes or subsequent law comes and there is an extension of the time limitation, it cannot revive the old action which has already become time barred and which has already gone into the grave. Are you getting my point? Now, already 13, 14, 14, 15, 15, 16 got time barred at their respective junctions. It cannot be reincarnated in the new law just because the time limit of 10 years is given in the extended time period. Are you getting my point? That is what Supreme Court said in KM Sharma and SS Gadgil. There is an old ruling of Supreme Court SS Gadgil. You can note this order also, SS Gadgil and KM Sharma. So my opinion is this, humble opinion, although it will be now a fierce battle between the department and the assessees. My view is this, Chitle Sahab, that Supreme Court decision in case of KM Sharma 254 ITR 772 and this 149(1)(b) first proviso and CBDT instruction dated 10 December 2021 and Rajasthan High Court Sudesh Taneja para 37 all combined together, in my opinion, all these assessment year 13, 14, 14, 15, 15, 16 are time barred. They should not be touched. Aap bolenge Mr. Goel, then how should we reply now? I am giving a template reply to you. Please take fast note of it. If I am to frame a reply, if I am to draft a reply, how will I draft it? For 13, 14, 14, 15 and 15, 16 I am telling. In my humble suggestion, one is free to adopt its own way. This is my humble suggestion because I am invited here. So it is my duty to share it with my viewers. But it is no compulsion. Please don't take it in a otherwise manner. I am just saying it in a humble sense. Somebody can have a better way of drafting than me. So what I am pointing out, Chitle ji, that if I am to draft a reply for these 3 years on the notices which now department is giving as per Supreme Court decision, first point I will take, sir, is that this is time barred proceedings. You can note down. First bullet point will be it is time barred. I hope my point is very clear, sir. As per 149(1)(b) first proviso, Sudesh Taneja's case, CBDT instruction dated 10 December 2021, and all those things which I have just told, sir. First point will be, Chitle Sahab, it is time barred. Second point you can take is, you please note, this is very important point, sir. Second point is how to apply extended period of limitation. अभी क्या हो रहा है अनीश भाई कि पूरा इंडिया में सब लोगों का एक ही सवाल है कि मान लेते हैं ये वाला पॉइंट हमारा नहीं चलता है मिस्टर गोयल की दैट दीज आर टाइम बार्ड, फिर क्या होगा, व्हाट नेक्स्ट? आई एम गिविंग ए अल्टरनेट पॉइंट, यू मस्ट बी नोइंग इट, आपको सबको पता भी होगा अभी तो। पहला पॉइंट हुआ टाइम बार्ड, दूसरा पॉइंट आप लिखिए अल्टरनेट पॉइंट, it is extended period of limitation, then 3 jurisdictional conditions are specified under 149(1)(b). What are 3 jurisdictional conditions? It's a special criteria of reopening under the new law in extended period. In new law, we all know there are 2 brackets of reopening compartments, one till 3 years and one beyond 3 years. Beyond 3 years, Chitle Sahab, the law says, I am reading, I want to emphasize on this in today's seminar, because ये मैंने आपके पहले डिस्कस नहीं किया, ये मुझे भी अभी पता चला है, ऐसा पढ़ना पड़ेगा इसको। Now, what department is doing, to my surprise, Chitle ji, and Direct Tax Committee should bring it to the notice of CBDT, how they are issuing the notices for extended period also, sir, they are simply saying this is the information there. But I am saying this criteria is not applicable at all for extended period, sir. What is the criteria? Correct criteria, please note, 149(1)(b) says, if 3 years but not more than 10 years have elapsed from the end of relevant assessment year, unless means it is mandatory condition. Condition precedent, unless the AO has in his possession books, document, evidence. Please pardon me for my way of telling you, but it has to be told like that. Books of account, document or evidence. Now sir, there is no information word here, sir. Extended period में information word है कहां? इन्होंने तो सब केस में explanation word डिपार्टमेंट ने लगाना चालू करा है अभी तो सर। I am sorry, in 13, 14, 14, 15, 15, 16, if these are not time barred according to CBDT, then the criteria which is special criteria for this extended period is number 1, books, document, evidence in possession of AO revealing escapement of income. What is revealing, sir? Why it is not suggesting? वहां तो लिखा है information suggesting escapement of income, यहां लिखा है books, document, evidence revealing escapement of income. What is the difference between revealing and suggesting? Are they same? Is information equal to books, document, evidence and suggestion equal to reveal? I'm sorry, I don't know that English. And why it is happening कि they have just reduced it to 50 lakh का फिगर पे आ गया, वो तो कह रहा 50 लाख से ऊपर या कम। सर वो एक कंडीशन है, बाकी भी है उसमें सर। बाकी कंडीशन क्या है? पहला कंडीशन है बुक्स, डॉक्यूमेंट, एविडेंस इन पोजेशन ऑफ एओ डिपार्टमेंट रिवीलिंग दैट, रिवीलिंग, नाउ प्लीज यूज नोट द वर्ड रिवीलिंग का मतलब कंक्लूसिव एस्टेब्लिशमेंट ऑफ द फैक्टम ऑफ एस्केपमेंट ऑफ इनकम, not any doubtful escapements are revealing. Now it should be represented in form of Sameer bhai asset. वर्ड लिखा अगला लर्ड है रिप्रेजेंटेड इन फॉर्म ऑफ असेट, मतलब अगर आप मुझे कोई पुराना साल का नोटिस देते हैं जो एक्सटेंडेड पीरियड का नोटिस है, तो वेओ को ये प्रूव करना है डिपार्टमेंट को कि मेरे पास उस एस्केपमेंट के इक्वल आज कोई एसेट है मेरे पोजीशन में, आज इस समय अभी, और वो एसेट कौन सा वाला एसेट जो इसकी एक्सप्लेनेशन में डिफाइंड है नीचे। अब चिटले साहब सोचिए, जो इंफॉर्मेशन ये लोग अभी डिपार्टमेंट हमें दे रहा है 13, 14, 14, 15, 15, 16 में, क्या वो इसके फिल्टर के हिसाब से 149(1)(b) का कंडीशन के हिसाब से सही है सर? है जी, बिल्कुल नहीं होना चाहिए था वो तो सर, अभी तो गलत होता है वो तो। बुक्स, डॉक्यूमेंट, एविडेंस कहां है, रिवीलिंग कहां है, रिप्रेजेंट इन फॉर्म ऑफ असेट कहां है, वो तो सिर्फ 50 लाख से चल रहे हैं। इट इज रॉन्ग, दे हैव सॉरी, सीबीडीटी हैज रॉन्गली गिवन दिस इंस्ट्रक्शन। आई एम डिसअपॉइंटेड। वो तो उन्होंने 3 कंडीशन का एक बना दिया है सर। 3 का एक कैसे बन गया सर? वो जादू कैसे हुआ? वो 3 कंडीशन अलग अलग हैं, बुक्स, डॉक्यूमेंट, एविडेंस इन पोजेशन ऑफ एओ रिवीलिंग एस्केपमेंट ऑफ इनकम, देन रिप्रेजेंटेड इन फॉर्म ऑफ असेट, देन मॉनिटरी थ्रेशोल्ड ऑफ 50 लाख पर ईयर। दीज आर 3 सेपरेट कंडीशन नीड्स टू बी क्यूमुलेटिवली फुलफिल्ड। तो मेरे रिप्लाई का पहला पॉइंट था टाइम बार्ड। दूसरा रिप्लाई का पॉइंट हुआ कि ये एक्सटेंडेड पीरियड का लिमिटेशन का जुडिक्शनल क्राइटेरिया पूरा नहीं हुआ। फाइनल कंटेंशन, ये आप अपने तरीके से चेंज कर लें, इसको एलैबोरेट कर लें। फाइनल कंटेंशन इसका ये बनेगा नीश भाई कि साहब जो एस्केपमेंट वो बता रहे हैं इंफॉर्मेशन का बेस पे, वो इंफॉर्मेशन रेलेवेंट है, रैशनल है, या वो जिसका आपसे कनेक्शन है या नहीं है। तो थर्ड पॉइंट इज दैट यू विल हैव टू डेमोन्स्ट्रेट और वी विल हैव टू से कि दिस क्वालिटी ऑफ द इंफॉर्मेशन विच डिपार्टमेंट इज रिलाइंग अपॉन हैज नो एक्सेस एंड कनेक्शन टू लीड टू चार्ज ऑफ एस्केपमेंट ऑफ इनकम इन द न्यू लॉ। अब चिटले साहब, आई वॉज रीडिंग दिस वन बुक बाय चैम्बर ऑफ टैक्स कंसल्टेंट का भी एक किताब आता है, वो जो जर्नल आता है आप भी पढ़ते होंगे, उसका इस महीने का जर्नल बड़ा अच्छा आया। आप जो भी चैंबर ऑफ टैक्स कंसल्टेंट का रीअसेसमेंट का भी पूरा उन्होंने एक मई का भी दिया है, एंड इट्स वर्थ रीडिंग, ट्रीट टू रीड। सोरपारकर साहब, चैतन्या साहब, एवरीबडी हैज एंड एवरी वेरियस लर्नेड एंड एरुडाइट पीपल हैव रिटन इट। मैं उसका एक समरी पॉइंट बताना चाहता हूं आप सबको आज का अभी सेमिनार में सर, जो मुझे पहले नहीं बताया आपके चिटले साहब। अब देखिए, पुराने वाला 147 को और नए वाले 147 को पढ़िए। पुराने वाले 147 मैं पहले पढ़ रहा हूं चिटले साहब। पहला पुराना वाला 147 जो सेक्शन मेन है वो कैसे स्टार्ट होता था? If the assessing officer has reason to believe that any income chargeable to tax has escaped assessment. This was the opening lines of the earlier 147 section prior to 1st April. Now what is the current 147? Anishji, kindly note that serious radical change has come. Now new 147 Samir Bhai says, if any income chargeable to tax in the case of assessee has escaped assessment, meaning thereby there is a fundamental change in the position of law. That even now today if 147 has to done, it cannot be done just merely on basis of suppositions or some kind of prima facie evidence. It has to be conclusive escapement of income. I'm sorry, this is how you have to read it. Earlier 147 was based on reason to believe as leading to escapement of income. Now the 147 language says if any income chargeable to tax has escaped assessment. What is the difference? So, Chitle Sahab, are you getting my point? Now in 147 in the new law, it has to be a firm establishment of factum of escapement of income. And Rajesh Javeri and Raymond Woolen Mills are gone days. They cannot be applied in the new law. Sorry, department is still relying upon it. This is totally wrong. Raymond Woolen Mills and Rajesh Javeri cannot be applied in the new section 147 due to change in the position of the language of the law. I hope I have clarified my reply. I will repeat. First, you say that the proceedings are time barred as far as AY 1314, 1415 and 1516 is concerned. Second, we can say if extended period of limitation is applicable under section 149 1B, whether the three jurisdictional condition of books, document, evidence revealing escapement of income represented in form of asset, more than 50 lakh rupees are fulfilled or not. Second point. Third, quality of information is B speaking for itself or not, sir. This will draft a comprehensive reply, Chitle Sahab. And insist, note it down. Please take a sharp point that every relied upon information you have to ask, the department has to give it to us. And personal hearing you should also ask. You ask for personal hearing, I want to come to explain to you my facts. Oral hearing and this relied upon information. इतना क्लियर हो गया सर? It is digested. अब आप बोलेंगे मिस्टर गोयल इतना सब मेहनत करने के बाद अभी डिपार्टमेंट उसको ड्रॉप करेगा, उसका ऑर्डर पास करेगा और उसको क्या करेगा ये तो मुझे नहीं पता है, मैं इसको ऐसे तो नहीं बोल सकता हूं, बट इन माय हम्बल ओपिनियन इट लुक्स नॉट वेरी मच व्हाट यू से प्रोबेबल दैट दिस एक्शंस 148 का जो अभी पुराना लॉ से ये न्यू लॉ में आ रहा है वो ड्रॉप होगा अनिश भाई. मे बी समबडी हु इज हैविंग लाइक कैपेबिलिटीज लाइक समीर लाडा जी or somebody else who is a juggernaut and having handsome personality like Anish bhai, so he can get it dropped. But it's not that easy to get it dropped. I hope my point is well taken note of. So वो question मेरे से बहुत लोगों ने पूछा कि Mr. Goyal, how do you expect this department will drop it or not? The way CBDT has given its instruction, I feel it very. See, maybe somebody could take it in a different fashion. That yes, there is still room for dropping, but I would humbly put my point of view that it is like this, the department will definitely take this battle to the new side or further side. So yes, we have to make a better reply. That is how I have already told you that you take all possible contentions and make it a comprehensive reply. Do not leave anything, sir. Chitle ji, whether it is time barred contention, whether it is extended period of limitation contention, whether it is quality of information wala contention. And now I want to tell you 4 or 5 important judgments which has just come on new 148. See, already ये तो अभी सुप्रीम कोर्ट ने चेंज कर दिया, पर वो वाला लिटिगेशन तो चल ही रहा था ना, जिस पे चिटले जी लास्ट टाइम हम मिले थे कि जो इन्होंने 148 कैपिटल ए में फ्रेश 148 ए दिया. And already my lot of viewers would be aware, although, but it is my duty that some might not be aware. There is a very important decision of the Honorable Delhi High Court, sir. And this decision needs to be taken note of by everybody, sir. This is in the case of Divya Capital. Divya Capital. This is a Honorable Delhi High Court decision dated 12th May 2022 in the case of Divya Capital. Now in this decision, sir, the case of Divya Capital, the Honorable Delhi High Court order, sir, 12 May 2022, 12th May 2022. Now in this case, it's very interesting to read this order, sir, because it tells not only this order copy has been sent to CBDT chairman also, that quality of 148A which is happening is absolutely lacking. If I read one paragraph of this order, sir, it's a detailed order. 1 lakh crore escapement. I don't know how much figure is this. मेरे को तो पढ़ने में भी नहीं आया. वो बहुत बड़ा figure है. I don't know how much. Somebody was telling me it's like rupees 1,705 crore 88 lakh 4,000. I don't know how to read this. So it's a very, मतलब वो जैसे हमारा जैसा आदमी तो भी figure ही नहीं पढ़ पाता है उसको तो. Anyhow, this is the quantum of escapement in this case. The fine point of this decision starts from para 7. Now, what it says, pehla point, first act point, and it's to be noted very sharply by my viewers, Chitleji. New reassessment scheme was introduced by the Finance Act with the intent of reducing litigation and to promote ease of doing business. I'm sorry. This objective and goalpost is yet to be, it's looking very far, sir. People ask me, Mr. Goel, where is this litigation reduced? And where is the ease of doing business in all this? So High Court says, Honorable High Court says, Delhi High Court, the court is of the view that under the amended provisions, the term information in explanation 1 to section 148 cannot be lightly resorted to so as to reopen an assessment. Meaning thereby, Delhi High Court makes a very clear point that just because there is an information in their system, portal, that cannot be ipso facto automatic based to reopen the case in the new regime. This is what para 8, page 6 of Delhi High Court order says. This information cannot be a ground to give unbridled power to the department. Whether it is information to suggest under the amended law, High Court says, or reason to believe under the erstwhile law, the benchmark of escapement of income chargeable to tax still remains the primary condition to be satisfied before invoking 147. So what it means? So it means that escapement of income is still the ground norm. Then they say merely because the respondent department classifies a fact already on record as information, it may vest with the power to issue a notice of reassessment, but would certainly not vest with it power to issue a reassessment notice under 148, post an order under 148AD. What it says, it's a very important line. It says, Anish bhai, कि सिर्फ इसी merely because of this reason कि आपने कोई information को computer में डाल दिया है, उसका मतलब ये नहीं हुआ कि आपको 148A देना ही देना है. Are you getting my point? So, para 8 of Delhi High Court says that just because you have brought new criteria of information, that does not give unbridled power to the revenue, and income escaping assessment remains the ground norm. Supposingly, there are 100 of cases, चिटले जी, अभी किसी ने बोला कि डिपार्टमेंट ने बोगस परचेज करके कोई 148A दिया और उससे हमने बोगस परचेज तो कुछ नहीं करा हुआ था, बट उसको सेल किया हुआ था. Whether that action under 148A will sustain under the law? Answer is no. Sale and purchase are not interchangeable classifications, sir. Sorry. And who will appreciate more than an accountant? Department alleges in 148A show cause and order that it's a bogus purchase, but where is the fact of the matter is this? It is a sale. It's a classical case of non-application of mind. It's a classical case of, misuse and abuse of power. It's a classical case where provisions are used for extraneous purpose and purpose beyond the statute. It's a classical case where the power given under the 148 has not been used for the purpose for which it has been given. You can say it any way, but the fact remains कि अगर आपने purchase नहीं किया है और allegation bogus purchase का है, then that 148A cannot sustain. Para 8, I hope it is clear, Delhi High Court, Divya Capital. Now I read para 10. Now, court says, this court is of the view, High Court says that even if the reassessment was being done for verification in accordance with explanation 1, that 148A का purpose verification है, Nothing prevented the AO from conducting an inquiry with respect to said information in accordance with 148 capital A clause A. In any event, it was all the more necessary in the present case for AO to thoroughly scrutinize the contentions and submissions. Now, what is happening? चिटले साहब ये सारा ऑर्डर जितना भी पास हुआ है ज्यादातर, और हाईकोर्ट का रिमार्क है भाई साहब बहुत सीरियस स्ट्रिक्चर है पैरा 16 में, दे से इट्स ए टेम्पलेट ऑर्डर्स. ये ज्यादातर ऑर्डर टेम्पलेट ऑर्डर है. कैन यू इमेजिन? आई कैन रीड इट. दिस आई एम नॉट यूजिंग दिस फ्रेज. जस्टिस मनमोहन हैज यूज्ड इन दिल्ली हाईकोर्ट ऑर्डर. इट सेज significance of issues of show cause notice under 148A at a stage prior to issuance of 148 notice under 148 has been lost on department. वो कह रहे हैं कि जो नया लॉ है उसके अंदर जो शो कॉज नोटिस का परंपरा है या मर्यादा है उसका डिपार्टमेंट के ऊपर कोई असर नहीं पड़ रहा है. और मैं आपको अगला पैरा पढ़ के बताता हूं, पैरा 16 जो इसमें है इसके हेडिंग का नीचे. This court is of the opinion that significance of issuance of a show cause notice at a stage prior to issuance of a reassessment notice under section 148 has been lost on the respondents. This court takes judicial notice that in majority of reassessment notices post 1 April 2021, the orders which are passed under 148A capital clause D uses template and general reason to reject the defense of the assessee on merits. Consequently, this court is of the opinion that a progressive as well as futuristic scheme of reassessment whose intent is laudatory has in its implementation not only been rendered nugatory but has also had an unintended opposite result. सर ये बताइए, ये इतना इंपॉर्टेंट जजमेंट है, इससे तो ये पता चलता है कि जो अभी पहले 148A का जितना भी ऑर्डर पास हुआ उसका क्वालिटी क्या है. और अब मुझे लग रहा है, मेरा हम्बल पॉइंट है, सॉरी आई कैन बी रॉन्ग, कि जो अब ये सुप्रीम कोर्ट से परिवर्तित 148A होगा डी ऑर्डर, वो ये ना हो जो पैरा 16 बोल रहा है. आई एम हैविंग एन हम्बल एप्रीहेंशन एंड फियर which Mr. Manmohan, Justice Manmohan has elevated in this Divya capital case. Anyhow, you can all take note of this Divya capital case, and in this order, Honorable High Court has given a another very important point in paragraph number. You can note this also, which is very important. Paragraph 11 में क्या लिखा है हनी जी? Para 11 में they say every relied upon information has to be gently and genuinely shared with the assessee as a matter of principle of natural justice. Para 11. And if it is not shared, then entire 148AD will become wrong. So Chitleji, Divya Capital is a good judgment. It shows the path, and at least if department has to healthily implement it, rather I thought कि जो उनका CBDT का instruction है उसको उनको change करना चाहिए. They should include this Divya Capital case in that instruction. Then it will become a healthy, balanced and objective exercise. Now, after all this, sir, I have already told Rajasthan High Court development constitutional validity wala point, risk management strategy. Delhi High Court I have discussed, sir. Just a minute. Now, there are various other high courts because it's a direct tax committee program. Calcutta High Court recently, in one of the cases by division bench, I will tell this decision also to my viewers. My viewers can note it, sir. This is the case of Calcutta High Court in case of RN Fashion versus Union of India. Calcutta High Court, RN Fashion versus Union of India, order dated 20th May 2022. RN Fashion versus Union of India, 20th May 2022, Calcutta High Court Division Bench, Justice T.S. Sivanganam, who is also a very tax juggernaut. He says in this order, चिटले साहब, डिपार्टमेंट के ऑफिसर को उन्होंने बोला कि इसमें लिखा है, उन्होंने, मैं इसमें से पढ़ के बोल रहा हूं, उन्होंने बोला कि इन ऑफिसर साहब को इतना जल्दी था, टीयरिंग हरी में थे कि उनको किसी तरीके से 148A का ऑर्डर असेसी का खिलाफ पास करना ही था, और इसके लिए उनको दंड क्या दिया गया वो लिखिए. उन्होंने कहा कि मैं कॉस्ट इसलिए लगा रहा हूं जज साहब ने कि टू एज ए डेटरेंट टू दिस ऑफिसर्स की हु आर पासिंग दिस ऑर्डर्स लाइक ए एम्प्टी रिचुअल. एंड दिस RN Fashion case also takes cognizance of Delhi High Court 12th May Divya Capital decision. This decision of Calcutta High Court in RN Fashion is taking cognizance of 12th May decision of Delhi High Court in Divya Capital. So personal cost has been imposed, personal cost of 15,000 on the AO to pass an order, invalid order 148AD order in tearing hurry. So Calcutta High Court, I have told sir RN Fashion case, and they have said that if an assessee files reply, if assessee wants to have some more time, even under the new law, sir, if you go to section 149(1) and third proviso, what it says ki if assessee asks more time under 148A inquiry, that time will be added in the time limitation. So there should not be any hurry on part of department to pass the order, undue orders, hasty orders. So Calcutta High Court, I have told this Delhi High Court, in my opinion, there is one more development from Gujarat High Court. Justice Padiwala, before being elevated from Gujarat to High Court to Supreme Court now, he has been again a very famous tax judge. And he has written a lot of judgments on GST also, sir. Justice J.B. Padiwala in Gujarat High Court has written two beautiful orders on 148 capital A clause D. You can note the name, Mahananda Enterprises and Vimal Shrewala. There are two Gujarat High Court orders, sir, on 148 capital A, new wala 148A, Gujarat High Court. That is Mahananda Enterprise Private Limited versus ITO, order dated 2nd May 2022. And second is just a minute, I am telling second one. One is Mahananda Enterprises and another is there. My brother is telling me Shrenik Vimalwala. Sandeep ji is telling me this is second decision. Shrenik Vimalwala. And in this decision, also Gujarat High Court has also said, Chitle Sahab, that 148A capital A purpose is to give meaningful opportunity to the taxpayer to explain its point of view, that why 148 should not be used in its case. And it cannot be made a empty ritual and idle formality. That is what Gujarat High Court has also said. Delhi High Court, Calcutta High Court, Gujarat High Court, and various other high courts also, sir. Madras High Court, Odisha High Court. I have all these decisions High Court wise also with me. So they have said and they have commented, sir, judges, honorable lordships of the High Court, again on the very bad and poor quality of these orders, sir. In many cases, they have not even given that 7 days minimum time period clear days notice. 7 days का clear notice ही नहीं है. अब बताइए साहब, ऐसा इनको, सॉरी टू से लाइक दिस, कि डिपार्टमेंट को क्या इतना प्रॉब्लम होता है कि 7 दिन का नोटिस देने में एसएससी को, सर? जबकि कानून में लिखा हुआ है कि वो जो 7 दिन मिलेंगे वो 149 का लिमिटेशन में ऐड हो जाएगा. तो क्या प्रॉब्लम है? 7 दिन की जगह 3 दिन दिए जा रहे हैं. और उसके बाद एसएससी का रिप्लाई फाइल होता है, उसको बिना कंसीडर करे ऑर्डर आ जाता है. वो कहते हैं हमें रिप्लाई दिखाई नहीं सिस्टम पे. हाउ इज दिस पॉसिबल? आई एम एट अ लॉस. When I see the court rulings, High Court rulings, sir, honorable High Court rulings, that saying that these orders are passed under 148AD, even do not consider that reply filed on the portal by the taxpayer. I am sorry, I am at a loss. How is this? It is unfathomable, inexplicable to me. So, to complete this chain of discussion, sir, I believe 148 capital A is a very serious process. There are two brackets, one normal period, 3 years, and one special period, extended period, more than 3 years. In extended period, department has to fulfill the special criteria. In normal period, they have to fulfill the general criteria of information suggesting escapement of income. But information is not gospel truth, not synchronous. It can be objected, it can be repudiated, it can be contested. It can be proven to be erroneous, factually incorrect and wrong. And then assessing officer is under a duty to drop that proceeding if it is shown to be wrong, non-existing, unfounded, baseless. So, in my opinion, this is how this whole exercise has to be taken place. And 149 subsection 1 clause B first proviso has to be strictly implemented. Time limitation. And extended period 3 conditions have to be strictly seen. Many people have asked me what is this criteria of asset. I have told only when in the extended period there is an undisclosed asset in the possession of assessee, unrecorded asset, then only beyond 3 years you can go. That asset means unrecorded, undisclosed, unaccounted asset, not recorded asset. This is also to my mind very clear. So, now there are 3 High Court decisions, Samir bhai, and I'm telling you, worth noting. We all have seen some tough time for chartered accountants. And we are all worried for our professional brothers and colleagues. But I'm telling you how High Court Chitle Sahab has come down. Chitle Sahab, I don't know whether he's there or not. But in last 1 week or 2 weeks, Hanish bhai, I'm telling you now, I'm going to tell 3 landmark epochal path-breaking order from 3 different High Courts on income tax. And malab eye-opener. One is the decision of Rajasthan High Court of last day. एक ट्रीट टू रीड मैं आपको भेज चुका हूं चिटले साहब, आप अपने व्यूअर्स को अपनी कमेटी में जो भी भेज सकते हैं. राजेंद्र कुमार वर्सेस ACIT, This is the decision of Honorable Rajasthan High Court, Rajendra Kumar versus ACIT, order dated 25 May 2022. कल का ऑर्डर है. Rajasthan High Court, Rajendra Kumar versus ACIT, and 50,000 rupees cost has been imposed. It was a case, I say summary sir. In this case, assessee filed an appeal against an assessment to the CIT appeal. Somehow that appeal could not be decided or taken up for hearing for more than 1.5 years. In the meanwhile, department, to recover in its anxiety to recover the demand, adjusted 100% of its demand against the pending refund and did not remain confined to 20% norm of office memorandum. So now in this background, Rajasthan High Court has said and passed strictures. Justice Samir Jain says that we are consciously passing strictures on the income tax department because their actions are violative of constitutional articles. Article 14, Article 21 and Article 265. You can note down Article 14, Article 21 and Article 265. And they say that it is high time that department and CBDT raises the eyebrow that at one hand they do not dispose the appeals for number of years, Samir bhai, and on the other hand they want to go behind recovery. Is it right? They say it is an act in terrorum. I am not using this phrase. My lord have said it is an act in terrorum. Justice Samir Jain, speaking for Rajasthan High Court last day, sending the order to Revenue Secretary and CBDT Chairman for taking corrective action and sensitizing the Income Tax Department for not using their power just for sake of doing it. There should not be any kind of misuse of power. When 20% norm is there and assessee कह रहा है कि साहब अब मेरा 20% ले लीजिए, तो भी उनको पूरा क्यों चाहिए? और इसके लिए अकाउंटेबिलिटी कहां है? एक तो आप मेरा अपील डिसाइड नहीं कर रहे हैं, ये हाईकोर्ट बोल रहा है, और एक तरफ रिकवरी करे जा रहे हैं. पैसा वापस करना पड़ेगा. और राजस्थान स्टेट लीगल सर्विसेज अथॉरिटी को हाईकोर्ट ने डायरेक्शन दे दिए हैं ऑर्डर के अंदर कि इस राजस्थान स्टेट में जितनी भी अपील पेंडिंग है उनका स्टेटिस्टिक्स हाईकोर्ट के सामने लाया जाए और बताया जाए कि क्या प्लान है गवर्नमेंट का उसको डिस्पोज करने का. इनकम टैक्स की फर्स्ट अपील. आई से इट्स एन इम्पोकल ऑर्डर सर. ये हमारा आवाज उन्होंने सुन लिया है, दुखी आवाज सर. Rajendra Kumar versus ACIT, 25th May 2022, Rajasthan High Court, speaking through Justice Samir Jain. And they have, मैं आपके सामने और पढ़ूंगा, आप कहेंगे उसमें ऐसे ऐसे वर्ड चिटले साहब उन्होंने जस्टिस जैन ने लिखे हैं. Justice Jain himself has been a counsel in tax law before being judge in the Honorable High Court. He has seen the tax law very closely, as I know. So only one who has seen this harassment from closely can appreciate the sentiments. I am telling you, he has used a phrase कि साहब absolute power corrupts absolutely. He has used in the judgment. He has used in the judgment that I am passing strictures and I am bound to that the Department of Income Tax should be sensitized that how they use their recovery powers. They have what you say interpretation 6 होता है ना, वो जिसमें हमारे को वो बोलते हैं हम तो पूरा पैसा लेंगे या 20% तो लेंगे. उन्होंने उसके लिए भी बोल दिया कि आप 20% नहीं ले सकते हैं. अगर असेसी का कोई वो नहीं है, कसूर नहीं है, ब्लेम नहीं है कि उसका अपील डिसाइड नहीं हो रहा है, फर्स्ट अपील. आप समझ रहे हैं सर? तो दिस इज ए वेरी वेरी इंपॉर्टेंट ऑर्डर. कॉस्ट भी लगाया सर. फिर दूसरा ऑर्डर मैं बताना चाहता हूं जहां रेवेन्यू सेक्रेटरी तरुण बजाज साहब का एफिडेविट इलाहाबाद हाईकोर्ट ने मंगवाया. इट वॉज ए केस, यू कैन नोट डाउन, इट्स ऑल्सो ए वेरी रिसेंट ऑर्डर ऑफ 17th May 2022, हरीश भाटी. The name of the order is sir Harish Chandra Bhati versus PCIT Noida, order dated 19th May 2022. ये भी एक इपोकल ऑर्डर है चिटले साहब. हरीश चंद्र भाटी वर्सेस पीसीआईटी नोएडा, 19th May 2022, इलाहाबाद हाईकोर्ट, जस्टिस एसपी केशरवानी. अब इस केस में जस्टिस केशरवानी को इतना उनको दुख हुआ, उन्होंने क्या देखा सर कि एक केस में असेसमेंट फेसलेस असेसमेंट होता है, हाई पिच असेसमेंट होता है और उसमें नेचुरल जस्टिस के वायलेशन हो जाते हैं, असेसी का रिप्लाई कंसीडर नहीं होता है, ब्ला ब्ला ब्ला. तो उन्होंने कहा कि डिपार्टमेंट अकाउंटेबिलिटी फिक्स करने के लिए हाई पिच असेसमेंट में क्या कर रहा है. और हम सब हाई पिच असेसमेंट को बहुत देख चुके हैं, कितना दुख होता, कितना दिक्कत होता है उसका, स्टे का और सबका. ये जजमेंट हरीश चंद्र भाटी का एक अपने आप में लैंडमार्क ऑर्डर है हाई पिच असेसमेंट को टैकल करने के लिए. अब जज साहब ने क्या किया, ये इसको असेसी ने क्या हुआ, मेरे को लगा असेसी ने अभी इसको जैसे जजमेंट बताता है असेसी एक बार पिटीशन फाइल कर दिया, बट जज साहब ने जब उसको सीरियसली अभी लिया कि साहब ये तो अभी गवर्नमेंट का अभी फेसलेस स्कीम में बड़ा फॉल्ट है, तो उन्होंने तरुण बजाज साहब का रेवेन्यू सेक्रेटरी का हलफनामा मंगवाया, एफिडेविट, कि आप हमें समझाइए कि आपका इस फेसलेस स्कीम में इतना सारा सब कुछ कैसे हो रहा है गलत. और वो सब आप इस ऑर्डर में देखेंगे चिटले साहब. Justice Kesharwani, Allahabad High Court compelled Income Tax Department, Government of India, Ministry of Finance, Revenue Secretary to issue a new circular कि साहब आपका जो भी हाई पिच असेसमेंट कमेटी है पूरे इंडिया में, स्टेट में, वो प्रॉपरली काम कर रहा है नहीं कर रहा है, आप इंश्योर करिए वो सब काम कर रहा है नहीं कर रहा है, और उसका ग्रीवेंस का क्या हो रहा है एसएससी का, और उस एओ के ऊपर क्या कार्रवाई हो रहा है जिसने हाई पिच असेसमेंट किया है. ये हरीशचंद्र भाटी में लिख दिया उन्होंने सर, और रेवेन्यू सेक्रेटरी साहब का एफिडेविट भी उसमें पूरा छाप दिया है, और साथ में जो नया सीबीडीटी का सर्कुलर है, सोचिए कितना इंटरेस्टिंग है चिटले जी. इस जजमेंट की वजह से एक नया सर्कुलर बोर्ड ने बनाया हाई पिच असेसमेंट को टैकल करने के लिए, जो हाईकोर्ट को दिया, वो अभी पब्लिक डोमेन में वैसे नहीं आया है, पर इस हाईकोर्ट के जजमेंट में रिप्रोड्यूस्ड है वो. और पूरा एक मैंडामस का मेरे अपने हम्बल एक्सपीरियंस में मैंने पहली बार हाईकोर्ट को देखा है कि मैंडामस का रिट में पूरा एक जनरल डायरेक्शन दिया है बड़ा लेंथ पे इनकम टैक्स मैटर में कि हाई पिच असेसमेंट में अकाउंटेबिलिटी फिक्स की जाए. और एक पैराग्राफ में सर उन्होंने, जज साहब ने अपना मन का एक बहुत अच्छा बात लिखा कि साहब टैक्स पेयर को आप रिस्पेक्ट से, डिग्निटी से ट्रीट करिए. दे आर ऑल्सो वेरी इंपॉर्टेंट पार्ट ऑफ इकोनॉमी. दे नीड टू बी ट्रीटेड विद डिग्निटी, नॉट विद इल डिग्निटी. दैट इज जस्टिस एसपी केशरवानी, Allahabad High Court, स्पीकिंग इन केस ऑफ हरीश चंद्र भाटी वर्सेस पीसीआईटी, ए लैंडमार्क ऑर्डर सर. फिर मेरे सामने जो डिसीजन अभी जो और हाई कोर्ट्स के कुछ डिसीजन आए सर, जहां पर उन्होंने अभी, जैसे इलाहाबाद हाई कोर्ट ने भी और भी हाई कोर्ट्स ने, जहां पर उन्होंने ये बात कही है कि डिपार्टमेंट, जो भी इनकम टैक्स डिपार्टमेंट है या टैक्स डिपार्टमेंट है सर, वो अपनी पावर को मिसयूज नहीं कर सकता है. और अभी आप देखिए हनीश भाई, कलकत्ता हाई कोर्ट का मैं बता चुका हूं, कॉस्ट इंपोज करी है जस्टिस सिमंगनम ने. तो इन सबको कंबाइन कर दीजिए. एज फार एज हाई कोर्ट्स आर कंसर्न, डिपार्टमेंट इज एट द इज टेकन, डिपार्टमेंट का जो भी उनका फॉल्ट लाइन है हाई कोर्ट्स ने, ऑनरेबल हाई कोर्ट्स ने पूरा एक्सपोज कर दिया है कि हाउ दे आर कंडक्टिंग दीज 148 प्रोसीडिंग्स, हाउ दे आर टेकिंग न्यू रीअसेसमेंट, how they are issuing show cause notice, how they are passing template orders, how they are not considering the replies of the assessee, how they are obdurate and obscurantist in their approach, how they are rigid and not inflexible and adamant in their attitude, and how they are not giving proper treatment to the taxpayer. I was also wondering, sir, कि my good friends asked me, Mr. Goel, कि whether this 148 capital A in the new law or the after Supreme Court decision, whether it will increase litigation or whether it will decrease litigation. The answer is very simple and plain, sir. And I believe it has become more limpid after our discussion that where direction we are heading towards. So I did not elaborate it more. Now we can take the queries which are there, sir. And thankful to all my viewers who are there in this webcast organized by Direct Tax Committee of Institute of Chartered Accountants of India. My good friend Chitle Saab, my elder brother Samir Bhai, Hanish Ji, and every other dignitary and my good friend is there. I feel blessed, sir. Thank you all of you.
Well, thank you, Kapil sir. Before we take today's the last session question and answer, we have with us a dynamic Central Council member, C.V. Chitre sir, who is also the chairman of Directors Committee. We are happy for his presence in today in our panel discussion. Sir, welcome again on behalf of all the participants and all the panel. I request you please kindly give your views on this section 148 before we take the question answer session. Over to Chitre sir.
Thank you, Samir. And I think views on section 148 are already presented in the seminar or the presentation by Kapil Bhai. So I will not go into it. I will just endorse that whatever has been dilated by Kapil Bhai is a treat for the purpose of tax practitioners. And I am sure that in this way, if the department keeps on acting, I think stakeholders will have to take serious note of it. And maybe Prime Minister's office also can be appraised of it. Because a recent episode that happened in case of GST at Ghaziabad also underlines such high-handed attitude. And I believe that in that high-handed attitude, suo moto action has been taken by the Honorable CBEC. In similar manner, in case of income tax, I think we have to, or the department has to trade along with the law, along with the guided principles of law. If it does not happen, courts are liberally taking the side of assessee, and not because they have any affinity for the assessee, but it is because of lack of following the principles of law, like natural justice and other things which are enunciated by courts themselves. So whether it is embedded in law or not, it is always understood that these principles have to be followed. Coming on behalf of Direct Taxation Committee, as you are aware, that only yesterday we have published compilation on the statement of donations received to be furnished by charitable institutions at the hands of Honorable President C.A. Devashish Mitra at Kolkata. We are also in the process of revising guidance note on tax audit. Maybe a draft would be ready by this month, or maybe 1st or 2nd of June, and that draft will be released. Those who are interested can claim that draft from Direct Tax Committee, and if any suggestions are to be made for improvement of this guidance note, these are welcome. Another 2 publications of Direct Taxation Committee, that is Taxation of Charitable Institutions and Audit of Charitable Institutions, 11, 12, 13, these are also under making. And now, because of this particular deliberations, I think one compilation of decisions under section 148, 148A, that also maybe we will take up, and with some summary if we publish, maybe at one go all these decisions would be available, and whenever the issue comes up of responding to these notices, I think rather than going here and there, maybe such important 10-15 judgments would be at the disposal of the professionals. So to this end also, maybe separately we will talk to Kapil and ask his views on which decisions we should include, and then accordingly maybe we can prepare some summary, also include these decisions in full form and make them available for the professionals. And I'm sure that I was not able to join from the beginning because as I'm at Guwahati for some another program for direct taxation, this course. But then maybe these lectures are recorded, and these are also uploaded on the website of DTC. So those who are not able to join today, maybe at a later date they would be able to listen this lecture at the convenient time, and they would be able to decipher the interpretation of this particular section, and whenever occasion arises, how to defend the case, of course, in a rightful manner. So I thank Kapil Bhai for being with us, and I'm sure that your patronage always is showered on our Direct Taxation Committee and the professionals in general. So that will continue in years to come. You have referred to certain judges and their strictures, and that they were earlier tax counsels. We also would like to see sometime Kapil Goyal is doing the judges.
So kind of you. I feel blessed, sir.
The appropriate judgments in appropriate language.
May Ma Saraswati come in your come there, and I would be definitely feeling blessed, sir, if it happens like that.
Yes. So with that, Samir, let us move on to the question and answers. If there are any questions on chat box, maybe you and Pankaj Soni can take them up.
Soni Saab, can you read it for me?
Yes, actually, I have the list of questions what the audience saying. I will read one by one for you,
No problem. Please.
sir. Actually, there are a lot of questions, so we will take them as many as possible.
No, you can avoid repetitive questions.
Yes, I will. I will answer.
No rationing from my side.
Yes. Okay. The first question from Mr. Ashok Katorka, sir. What will be the status of case where order is passed by AO under section 143(3) and High Court quash the notice and or oblique High Court pass an order and advise the AO to follow the Supreme Court order?
See, if I am rightly understanding what Mr. Ashokji is saying, there can be 4 contingencies, sir. You can note down. One is that contingency, and it will cover everything. एक तो वो this is one case where assessee has not gone into writ petition, sir, and his case was 148 was issued from 1st April to 30th June 2021. Now in this case, in my humble opinion, since the Supreme Court decision is pan-India based, and Supreme Court says this command is to be followed in the across India. In first category, I am saying that Chitle Saab, the notice was issued from 1st April to 30th June, and the assessee did not went to writ petition, and the proceedings are still pending. in that, in my opinion, that notice will now have to be changed to the new law. This Supreme Court decision should cover it also. There is some difference of opinion on this, but my opinion is this: even that assessee who has not went to the writ petition and his case is pending today, Anishji, which is issued a notice under 1st April to 30th June, then that will also to be mutated as per the procedure and guideline of para 10 of Supreme Court order. Second case is this, ki sir, who has gone into the writ and there the High Court has quashed it or the case is pending. Now that is very clear. Supreme Court has made it clear that is very absolutely clear in that case in which the High Court has already quashed it or the proceeding are pending before High Court, then this judgment will squarely cover to that second case also. That is made very clear. The doubt is there in first category, second category there is no doubt. Now in third category, if there is a case, sir, where notice was issued from 1st April to 30th June and writ petition was not filed, and assessing officer has already made the assessment before 31st March 2022. This is third case. I repeat, first case आपको clear हो रहा है? First case था जहां पर assessee ने writ नहीं फाइल किया था और उसका केस आज भी पेंडिंग है 1 अप्रैल का बाद का नोटिस का. In my opinion, that will get transferred to the new law. In second case, I told that assessee has filed the writ petition. Either the High Court has quashed it or not quashed it. That will also get converted to the new law. Third case is a difficult case, peculiar case, where the notice was issued from 1st April to 30th June and assessee never filed writ petition and department to its own peril has already completed the assessment on the basis of invalid notice. To my mind, this can never be converted because cause of action has been killed. उसमें assessee को क्या करना होगा चिटले साहब? अपील में जाना होगा उस assessment order के खिलाफ और CIT अपील को उसको क्वैश करना होगा. बात खत्म. मतलब बात खल्लास. वो चेंज नहीं होगा. जहां असेसमेंट ऑलरेडी ऑर्डर कर दिया है उन्होंने ओल्ड लॉ के नोटिस 1 अप्रैल से 30 जून वाला. दिस इज ए थर्ड कैटेगरी समीर भाई. फोर्थ कैटेगरी भी है. फोर्थ कैटेगरी में यह आया कि जहां नोटिस 1 अप्रैल से 30 जून में इश्यू हुआ, आपने कोई ना तो रिट फाइल किया और असेसिंग ऑफिसर ने असेसमेंट भी कंप्लीट नहीं किया और वो केस पेंडिंग है वो मैं पहले ले चुका हूं. तो इन दिस थ्री कैटेगरीज आई बिलीव एवरीथिंग हैज कम सर. एक केस कैटेगरी थोड़ा ट्रबलसम है जो अभी एक कुछ जगह हाई कोर्ट्स में केसेस चल रहे हैं कि जहां नोटिस 31 मार्च को इश्यू हुआ, सो कॉल्ड प्रिपेयर हुआ और उसको 1 अप्रैल के बाद डिपार्टमेंट ने डिस्पैच किया. वहां ये वाला जजमेंट लगेगा नहीं लगेगा आशीष अग्रवाल का, दिस इज $1 million क्वेश्चन. दिस इज वेरी ट्रिकी. आई रिपीट कि एक नोटिस चिटले साहब डिपार्टमेंट ने 31 मार्च 2021 को डिजिटल सिग्नेचर करके डिन नंबर लगाकर साइन कर दिया, बट उसको 1 अप्रैल को या 1 अप्रैल के बाद मेल किया. अब वेदर इट विल कम अंडर पैरा 10 ऑफ सुप्रीम कोर्ट और नॉट, इन माय ओपिनियन नो, बिकॉज दिस नोटिस इज डेटेड 31st March. So I believe I have comprehensively covered these 4 categories.
Next, what is the fate of notices issued after 31st/3/2021? I think you are covering this answer.
Sir.
Next, for AY 2018-19, client has received order under section 148 and dated 6/4/2022 was served, claiming escapement of rupees 37,91,000. This is below of rupees 50 lakhs. So can they issue notice under section 148? Notice under section 148A was received in March 2022. Kindly advise.
थोड़ा सा डिफिकल्ट है समीर भाई. दिस इज ऑल्सो आई गेट द क्यूरी लाइक दिस. दे से कि दैट असेसमेंट इज 18-19 and the 148 notice made might be proceeding should have been started in March as it looks like from query, and the order has been passed in April. So they say, चिटले साहब, the queries want to say, our learned colleague, कि साहब ये 3 साल के बाद ऑर्डर पास हुआ है, तो इट विल कम इन एक्सटेंडेड पीरियड एंड इट इज लेस देन 50 lakhs, so it should go. This is precisely his query, but I have a point. I have already told there is a section 149. 1, third proviso. It says that ki whatever time is there, 7 days time plus extended time, it will be added in 3 years, sir. Are you getting my point, Samir bhai? So it is like this ki 31st March plus 7 days. Are you getting my submission? So that is due to section 149 subsection 1 third proviso. So to my mind it is incorrect, correctly as far as 149(1) is concerned, third proviso. That thing has to be seen कि that information criteria is properly fulfilled or not, that escapement criteria, Divya capital decision, all those things.
No, only in this case, even if assessed income is less than 50 lakhs, still it is apprehension at the time of reopening the assessment or their judgment that it was more than 50 lakhs. Later on, assessment may be of less than 50 lakhs.
No. My point is something different, sir.
No, I understand. You talked on one point. I am talking on the other point of quantum.
But are you saying that कि नहीं मैं समझा नहीं चिटले साहब आप क्या कहना चाह रहे हैं?
नहीं, मैं कहना चाह रहा हूँ कि उसका ये कहना है कि मेरा 50 लाख से कम असेस हुआ है, तो वो पॉइंट 50 लाख के पॉइंट पे वो निकल सकता है क्या? तो 50 लाख का पॉइंट वाज फॉर द पर्पस ऑफ रीओपनिंग एंड नॉट फॉर द पर्पस ऑफ रीअसेसमेंट. अल्टीमेटली रीअसेसमेंट में रिजल्ट इनटू अ लोअर अमाउंट. But at the time when it was reopened,
this is a very, very sharp thing which you have told. I'm sorry, I'm not able to digest this. Sorry. You want to say, Mr. Goel, at the assumption of jurisdiction, if let us say there is an extended period after 3 years, and at the stage point they believe that it is more than 50 lakh.
Yes.
And you say, Mr. Goel, when he will make final assessment, let us say in 147, read with 143.3, that can go below 50 lakh. I'm doubtful. No. It will kill his jurisdiction. It will sublato fundamento carried opus will apply. Because it will have impact on his foundation of jurisdiction assumption. See, otherwise what will happen, Chitle Sahab? You can't say that this section 149 1B condition of 1.3 condition are not only for initiation of proceedings. In my opinion, they have to be there present in the case till the end. Till the end it goes to Mansarovar, Kailash or Ganga Sagar. It cannot be aborted. It should not be aborted. Otherwise it will frustrate the purpose of the law. It will give something to the AO which legislature does not want to give him. I am very glad that you approach this point. This is a very interesting point. I will further explore it.
And another thing that in earlier era, we said that, okay, whenever you are reopening, you are making addition. At least some addition has to be based on the point on which it is reopened. Maybe other additions you can make.
See, again you are today, sir. This is again a second interesting point. You see, in the earlier 147 section, now it's a very interesting thing. I am glad you have raised it. In the earlier law, there was a language and also any other income which comes to his notice subsequently during the course of proceeding. This additional language is not there in the new 147 main section. There is explanation 3. But in my humble opinion, if the basis, let us say there is one information coming to the AO on the basis of which he gave me 148A order and on the basis of which 148 is started. Now ultimately, Anish bhai, let us say if that information is found to be non-existing, baseless or no escapement is found on that information which is foundational information. To my mind, that Jet Airways and all other decisions which have come in the earlier 148 will hold good in the new law also. Meaning thereby, if the basis of the proceeding, that is the information, underlying information is not found to yield escapement of income, then proceeding will go. Should wither away. In my respectful submission.
Next, what will be the timeline for AY 2013-14 148 notices? Whether the extension of dates will having effect of competing the time limit under section 149(1) provision?
Sir, I have already told assessment year 13-14, 14-15 getting time barred on 31st March 2021, 15-16 getting time barred on 31st March 2022, and assessment year 16-17, 17-18 and 18-19 comes under extended period according to me, Samir Bhai. 149(1)B, 3 conditions have to be fulfilled.
Okay. Then in one case, addition of rupees 130.69 crores was made in the case of Asian Paints for spending as per company on trip expenses of dealers.
On which expenses of? On which expenses?
Trip.
Okay. I got it. Yes. Okay.
But as per AO, on freebuys or on pleasure trip. The case of dealer for assessment year 2016-17 has been reopened by dividing the total number disallowed in Asian Paint with the number of dealers. That is 130.69 divided by the number of dealers. That comes to 3.31 lakhs under section 148. Now under section 148B has been issued. Is it correct?
Sir, I believe there is some kind of thing which has gone overboard, extrapolation, too much extrapolation. See, I don't know how it is see, firstly the charge of the department allegation is this, Chitle Sahab, that some expenditure are claimed in the hand of the company, which they are claiming to be some kind of business promotion expenses. Now those business promotion expenses are treated to give yielding to income in the hand of the person who are dealer. I am yet to understand that suppose that how it is, there is only one section in the income tax law, Business Act 28 clause 4, business perquisite, which only says when it is given in kind, then it can be taxed. But it is in the business, this perquisite arising in the course of business. I am afraid this expenditure which is done by the company in its own hands, in its own independent capacity to promote its business, trip expenses, can it be called as perquisite to the given to the concerned dealer, taxable under 28 clause 4? To my mind, no. So as far as chargeability is concerned, it is weak. Secondly, the basis of the allegation is also hollow to my understanding, as it looks from the limited facts given by the jurist. Are you getting my point? The allegation, basis of the allegation and the chargeability of the income in the hand of the dealer is hollow. Chitle Saab can add.
No, what department is wanting to say that these expenses were not for the purpose of business promotion. So that's why in the hands of dealer, they got no business end survived by this particular trip. So it was a pleasure trip. So you were awarded pleasure trip because you are a dealer. Therefore,
But
because
sir,
of
see,
owning
this
your
line,
business, you are
no,
getting this benefit.
sorry. Now, this is a point gap here. Supposingly, we all don't know what is the exact reason on the basis of which disallowance has taken place in the hand of the company concerned. A.
Exactly.
Whether he says it's a personal kind of an expenditure or non-business expenditure or some kind of irrelevant expenditure. But my case is very different. Chitle Saab, 28 Roman 4 says, if you read section 28.4, what it says? It says which business perquisite will be taxable. Sir, it is a very limited section. And the onus is on the very revenue to say the value of any benefit or perquisite, whether convertible into money or not, arising from business or exercise of a profession. Then cause and effect relationship have to be established कि dealer को वो benefit मिल गया है. Supposingly the company is incurring that expenditure in its own capacity. It is not the benefit directly given to the concerned dealer, sir. That is what I am saying.
No, I understand, but see, he is issuing notice. He is not saying that this is your income. He wants to inquire. Then if he
No. There is a point, sir. In 148 capital A clause A, it's not inquiry. It's clause B. It show cause notice that information is there in their possession which suggests escapement of income. Now go to the word suggestion. Go to the word income escaping assessment. Now there has to be some charge. There has to be some charging provision. There has to be some provision where I can be taxed on this transaction as far as dealer is concerned. In my humble opinion, that is weak. See, if it is prior to show cause inquiry, 148 capital A clause A, then it is fine. But if it is 148A show cause, then to my mind it is wrong.
Exactly. So you mean that when you are issuing this show cause, at that point of time, you should be cocksure that yes, this is an income.
Sir, otherwise तो फिर क्या होगा? Otherwise क्या होगा चिटले साहब कि show cause के बाद inquiry होगी ये वाली.
Right, so show cause you can inquire, but you cannot issue notice unless you are sure that yes, this is income which has.
इसीलिए वो जो 148 कैपिटल ए का फ्रेमिंग है, क्लॉज ए में इंक्वायरी है सर. आई रिपीट, क्लॉज बी में शो कॉज है, क्लॉज सी में मेरा रिप्लाई है, क्लॉज डी में ऑर्डर है. हाउ दे डिपार्टमेंट इज डूइंग इंक्वायरी आफ्टर शो कॉज? दिस इज माय क्वेश्चन.
No, to that my response is, okay, they have made inquiry. After having made inquiry, the assessing officer forms opinion that yes, this is an income.
But in 99% of cases, sorry, I'm interfering. In 99% of cases, my gut feeling says and experience says that they have given go by to this clause A inquiry. They have straightway jumped to show cause, and in the guise of show cause, sir, they are doing the inquiry. That is the reverse model they are adopting.
Yes, so that is in not keeping with provisions of law.
Yes.
Now, if we assume that, okay, they make an inquiry, after making inquiry, assessing officer is of the opinion that yes, income has escaped assessment, then he issues notice under section 148A, and then the return is furnished.
At least at that stage. Sorry, sir. Sorry. Yes, please, sir. Sorry.
And then he makes the assessment. So where is question of assessment? He has already formed an opinion that yes, this is an income which has escaped assessment. So why he doesn't pass order? Why again he is making assessment? So in assessment there is not going to be any deviation.
There is a serious question which you are raising. Again, a very learned question, sir. You mean to say, Mr. Goel, if 148 capital A preempts everything, then what is the purpose of issuing 148 final notice calling for return of income and then framing the assessment? To my understanding, this is again going to be tested in courts of law very seriously. But to my humble understanding, जो मेरा humble opinion है, sir, correct me, 148A का D का ऑर्डर है, वो नोटिस तो नहीं है, और उसमें वर्ड लिखा है कि he has to pass an order that it is a fit case or not. after considering the material and reply filed by the assessee. So it presupposes due application of mind. It presupposes the existence of material in his possession, information in his possession suggesting escapement of income. It cannot be like this that it is made to now in the gar ki abhi dobara assessment hona hai, to usme ye sara cheez review ho jayega, to isse 148A will become farce, an empty ritual, and it will become preposterous. It will become a dead letter. It will become odious and nugatory, to my humble opinion. So some sense has to be given to 148A process, salutary process and sacrosanct process. That when they come to D clause, at least some fortified conclusion is there that it is a fit case. Now what is fit case? How you decide a case is a fit case or not? The word used in the law is fit case. In clause D of 148 capital A. To my mind, sir, you are right. Mr. Goyal, what will happen in the 148? It is $1 million question, sir. But I am telling you with my all humility, sir, the order has to be proper order. And it has to be with application of mind, considering the entire conspect of the case. It cannot be in a, as High Court has said in Divya Capital, in a template and general order, sir. As if all cases under 148A have to go to 148, that can also not be the spirit of the law. My respectful submission.
So do we say in 148A it should be again a reason notice that this is I believe this is the reason, and that's why I have formed the opinion.
That is the legislative intent. That was the legislative intent when they made this change. You know, sir. Otherwise GK and drive shaft will go to haywire. Now only GK and drive shaft hope is in 148A. Otherwise there is no separate GK and drive shaft in new regime beyond 148 capital A.
So here, for want of material, he cannot come to that conclusion, because that disallowance may be for any reason. It may be for cash expenses.
As I was saying you, sir, that in the earlier regime, Raymond Woolen and Rajesh Javeri came because the statute was framed in the manner that prima facie cause and justification is required. That Raymond Woolen case and Rajesh Javeri case. Now in the new law, when 148A is done, I am afraid you correct me, Chitle Sahab, there has to be even information suggesting escapement of criteria is upper, in my opinion, to reason to believe criteria. And AO has to demonstrate at 148A stage that there is something more than what you say prima facie view. Are you getting my point? Otherwise you will go down reason to believe, which is not the legislative intent, to my humble opinion.
Thank you.
Well,
very learned. Sir, all your points have been great, learned. I am also learning.
Well, great.
Everybody is learning.
Well, we are getting the gist of section 148 from the two great knowledgeable speakers, Chitre sir and Goyal sir. Next question: can department issue notice for STR, that is suspected transaction reports? Does it form part of information?
See, I have already told the criteria of information suggesting escapement of income. The word suggestion is very important. Black Law Dictionary, Chitle Sahab, other day I was reading this Black Law Dictionary, how it defines the word suggestion. Are you noting with me? The word suggestion is also not a loose word. It's a very serious word. There should be serious indication towards escapement of income. So I don't know whether department just by randomly uploading the information on the inside portal, can it be elevated to information suggesting escapement of income level or not? I'm in my own humble doubts. So just because a information comes into the portal, it does not become like this that it is ipso facto giving escapement of income, as Divya Capital, Mr. Justice Manmohan's order of Divya Capital para 8 and 7 clearly says. Samir bhai, Divya Capital para 7 and para 8 clearly answers it.
We have a lot of questions, many are repeated. Now, last two questions I will take. Please explain in detail first proviso to section 149 into 1 into P, as well as its applicability for AY 2015-16 along with proviso 3.
Sir, I repeat, I have said it number of times. There are 4 important things which you have to read together. First is section 149 1B, first proviso, the text of the law. Then you have to go to the memorandum explaining provision of Finance Bill 2021. Then you have to go to Rajasthan High Court, Sudesh Taneja, para 37. Then you have to go Samir bhai CBDT instruction dated 10 December 2021, para 5 and para 5.1. All coalesces together, read in conjoint manner, would lead to inevitable conclusion that first proviso has to be interpreted like this. कि आप आज नया वाला आज कहां है, वेयर यू आर स्टैंडिंग समीर भाई, वी आर नाउ स्टैंडिंग इन मई 2022, जून इज कमिंग. तो अगर आज आप 148 कैपिटल ए क्लॉज डी का ऑर्डर पास कर रहे हैं, सुप्रीम कोर्ट के डिसीजन के बाद, लेट अस से 15-16 ईयर का जो क्वेरीज पूछ रहे हैं, तो वो कब पास हो रहा है अनीश भाई? मई में पास हो रहा है। और चितले साहब वो तो 6 साल 31 मार्च को ऑलरेडी खत्म हो चुके हैं 22 को, तो वो अब टाइम बार्ड हो चुका है। That is what I am saying. AO has become functus officio on 31st March 2022 as far as AY 1516 is concerned. That is my humble opinion. And for that I have already cited CBDT instruction dated 10 December 2021, which supports my reasoning, and paragraph 37 of Sudesh Taneja's case. Even if we fail on that front, let me tell you, sir, it's not that the end of the war. It's the beginning of the road. उसके बाद भी तो सिटले साहब उनको तीनों कंडीशन पूरा ही करना है, जो मैंने बार बार बोला। रिवीलिंग बुक्स, डॉक्यूमेंट, एविडेंस, रिवीलिंग एस्केपमेंट ऑफ इनकम रिप्रेजेंटेड इन फॉर्म ऑफ असेट, दैट इज अनडिस्क्लोज असेट। वो कहां है? वो तो किसी भी केस में नहीं है। और इन दोनों में से अगर मान लीजिए टाइम बार्ड वाला नहीं भी बना, तो अगर आपका एक्सटेंडेड पीरियड वाले में आप आते हैं और डिपार्टमेंट को आप ऑब्जेक्शन दे देते हैं और डिपार्टमेंट नहीं मानता है, तो आप रिट में चले जाइए हाईकोर्ट। दैट इज द ओनली ऑप्शन टू यू।
Last question. Time limit to reply within
Before
40
that,
days.
in case of Samir, in case of revealing of assets, you mean to say that escapement of by way of expenditure will never come because money is already expended.
नहीं sir, no. Yes, there are 3 different compartments. Now one thing is very clear, as far as Supreme Court वाला portion is concerned, चिटले साहब, you will agree, and even CBDT instruction has agreed कि फाइनेंस एक्ट जो 22 ने 2 कंडीशन डाला है अलग से, एक्सपेंडिचर वाला और बुक एंट्री वाला, वो अभी नहीं लगेगा। और इवन जो 148 डिपार्टमेंट ने अभी किया है फाइनेंस एक्ट 22 के पास होने से पहले, उसमें तो सिर्फ असेट वाला क्राइटेरिया लगेगा ना भाई साहब। तो उसका मतलब ये हुआ कि असेट वो होना चाहिए। अच्छा, पहले 153 कैपिटल ए जब सेक्शन में यही सेम लैंग्वेज थी 6 साल से पीछे जाने के लिए, आप यू कैन नोट डाउन 153A फोर्थ प्रोवाइजो, सेक्शन 153A फोर्थ प्रोवाइजो में सेम लैंग्वेज है जो 149 1B में है। तो वहां पर सीबीडीटी का एक सर्कुलर मैं आप सबको बता रहा हूं, प्लीज नोट डाउन दिस सर्कुलर एक्सप्लेनिंग 153A फोर्थ प्रोवाइजो, सर्कुलर नंबर 2/2018 पैरा 80, सर्कुलर नंबर 2/2018 पैरा 80। हनीश भाई प्लीज नोट इट डाउन। दिस सर्कुलर सेज when they mean asset means investment in undisclosed asset. I'm afraid, Chitle Saab, if we read 149 1B in the shadow of circular number 2 of 2018, that is para 80, then majority of their notice is extended period will fall down, will crumble. Because there is no undisclosed asset. ना सर आप समझ रहे हैं, undisclosed asset का मतलब बड़ा clear है कि which is unaccounted, which is unrecorded, which is out of books of accounts. Supposingly, I have all my bank account transactions recorded in my books of accounts, and bank account is part of my books of accounts, it will never come to my mind under extended period. I am very clear about it. And department is using extended period to tackle recorded transactions also. That is wrong.
Thank you.
Last question. Time limit to reply within 14 days is to be calculated from the date of receipt of notice or 45 days from date of the Supreme Court judgment.
Sir, we have to read it in a manner in which we generally read the law कि जिस दिन और हमारे को नोटिस मिला है सर उसी से होगा। समीर भाई, लिमिटेशन का एक फंडा है, जब आपको कम्युनिकेशन हुआ भाई साहब तभी से मीटर डाउन होगा, उसके पहले नहीं हो सकता।
Great. Now I request Sri Pankaj Soni, former chairman of Allahabad branch, to kindly give the formal vote of thanks. Over to Pankaj. You are on mute, Pankaj. Kindly unmute yourself.
Hello. Good evening, everybody. I would like to thank Advocate Kapil Goyal sir for his pouring of knowledge on this important aspect of Section 148 and the related issues in which lots of litigations would be there in coming days. I am thankful to Direct Tax Committee Chairman CA C.V. Chitle sir and Vice Chairman CA Dr. Raj Chawla sir and whole Direct Tax Committee for conducting a webinar for the participants on this important aspect. More than 700 participants are still viewing, sir. Even after now, it is a dinner time. So this shows the importance of the topic and how eager they are always to hear you, Kapil sir. I, as a member of Aurangabad branch, we are very much eager to hear you physically and meet you here soon.
मैं जरूर आऊंगा सर जल्दी. मैं आई एम मिसिंग औरंगाबाद. चितले साहब के साथ आऊंगा.
Yes, sir, absolutely. Both are welcome. I'll talk to the present committee and plan something on that.
And I will go to that Shivji temple also.
Yes, sir, certainly. I'll definitely accompany you for that. Thank you, CA Hanish sir. And last but not the least, thanks to all the participants who have joined to make this webinar a good success. Thank you all. Over to you, sir.
Before we conclude, I just want to make one announcement that on 3rd and 4th June, there is regional conference in Pune. The first time the WRC is taking the regional conference out of Mumbai. So I request all of participants, please join the register for this regional conference if you have already not registered. Thank you.
Only one thing I wanted to say that कभी भी आप कपिल भाई को वोट ऑफ थैंक्स देते हो तो एडवोकेट से पहले चार्टर्ड अकाउंटेंट बोलिए तो सबको थोड़ा बेहतर लगेगा.
नहीं सही कह रहे हैं सर, ये बिल्कुल सही कह रहे हैं. मेरा आपसे मोह और रिश्ता ऐसा नहीं है. ये तो मैंने कई बार कहा है कि अगर मुझे दोबारा मनुष्य जन्म मिले तो मैं यही बनना चाहता हूँ. ये मेरी प्रार्थना है भगवान से, परमात्मा से.
Thank you.
Yes, sir. Thank you, sir.